Continue with this first week of our hearings over 2 weeks on the areas of child protection and criminal justice. But before we start, I'd like to ask Commissioner Hunter to do the welcome to country.
Thanks, Chair. I'd like to acknowledge and welcome you to my ancestral lands, the lands of the Wurundjeri people. Pay my respects to ancestors and elders, particularly here today. Acknowledge all those that come before us so we're able to have a voice and speak at these tables today. May Bunjil watch over us as we conduct Aboriginal business. Woman Jekka.
Thank you, Commissioner Hunter. Council.
Good morning, Commissioners. I'm appearing for this panel this morning, and Ms Fitzgerald is appearing for to lead the evidence of Auntie Rio after this panel. Before I call our panel members, we have some orders we wish to make under 26 of the Inquiries Act in relation to sensitive evidence. I hope they're on the table in front of you there, Chair.
Thank you.
These orders are in respect of the case studies set out in the confidential attachment to the witness statement made by Shelley Strickland, dated 6 December 2022, that those case studies not be published, that paragraph 19 and paragraphs 24 to 26 of the witness outline of Aaron Wallace, dated 6 December 2022, not be published, and any oral evidence in respect of either of those matters to the extent captured in a transcript or video recording not be published, and each order contains the usual warning in respect of contravention of the order. I seek orders in the form of those orders before you, Chair.
Thank you, Ms McLeod. I make those orders in terms sought.
So if the Commission pleases, I call today's first witnesses. We have Auntie Hazel Hudson, we have Felicia Dean, we have Shelley Strickland around the table in that order, and joining us in the body of the Commission hearing is Tracy Dillon. Online we have Aaron Wallace, who's muted at the moment.
Hello, Aaron. Welcome.
So for each witness, I might just check. We undertake a process where witnesses undertake to tell the truth, and there should be a form of words in front of you. I'll just check where those. Yes, those laminated copies. So, Shelley, starting with you, could I invite you to choose which form of undertaking you'd prefer and to read that out, please?
I, Shelley Strickland, solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
I, Felicia Dean, solemnly and sincerely declare and affirm that the evidence that I shall give will be the truth, the whole truth, and nothing but the truth.
I, Hazel Hudson, solely and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
And if Ms Dillon chooses to join us at the table, then we'll administer an appropriate undertaking as well. Mr Dean, do you have a form of words in front of you in relation to an undertaking to tell the truth?
Sorry, is that to me?
Yeah, sorry, Aaron.
No, I don't have the script in front of me.
Would you prefer to take an oath, make an affirmation, or give a truth declaration?
I'm happy to take an oath.
So would you repeat after me, please?
Yep.
Aaron Wallace.
I, Aaron Wallace.
Swear.
Swear.
By Almighty God.
By Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Will be the truth.
Will be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much, Mr Wallace. I think I called you Mr Dean then, I'm sorry. This morning's hearing, Commissioners, relates to the operation of Section 18 organisations, and I just wanted to remind you of the provision of the Act. Section 18 states, this is the Children, Youth and Families Act, the Secretary may in writing authorise the Principal Officer of an Aboriginal agency to perform specified functions and exercise specified powers conferred on the Secretary by or under this Act in relation to a protection order in respect of an Aboriginal child. So I might just invite, starting with Auntie Hazel, each of our witnesses to introduce themselves to you.
Hi everyone. I'd like to thank, for your welcome to country and acknowledge that I'm on Aboriginal land, pay my respects to elders past and present and any Aboriginal person within the room. My name's Hazel Hudson. I'm the Director of Family Services at Nernda Aboriginal Corporation. I've been working with Nernda for the last 5 years in that area. So I work with kids in out-of-home care, so kinship, Aboriginal children in Aboriginal care, the gardenership program, and family services, so intensive family services, homelessness and family violence area. I'm a Kamilaroi woman. I've lived down on Yoorrook country for 58 years. Moved to the country with my parents. I have Yoorrook children, and I've mostly worked in as an accountant in the New South Wales Aboriginal Land Council sector, and had a career shift 5 years ago where I went into the community sector. So I had a massive learning around that. And the reason I did that is because my parents and my grandparents had a belief that when you've had a privileged life, you pay back. So as you can plainly see, I'm in the last ends of my employment life. So I'm paying back to community in an area that needs lots of support around children who have broken lives because of one reason or another, and I believe in the village concept. So,
Thank you, Auntie. Ms Dean, would you prefer use Felicia or Ms Dean?
Felicia's fine.
Thank you. Please introduce yourself to the Commissioners.
Okay, so first I acknowledge and pay my respects to the Wurundjeri people and those elders past, present and emerging, and I pay my respects to you as Commissioners and thank you for your commitment to these really important roles. I'm a proud Yoorrook Tangarong woman, born and raised in Shepparton, and I'm the CEO of Rumballara Aboriginal Cooperative. I've been working at Rumballara on and off for about 20 years. So I have a background prior to that as a kindergarten teacher and hold a Bachelor of Education in Early Childhood. Rumballara is it's a very large Aboriginal community-controlled organisation, and it provides whole-of-life services from birth to death. And, we try to provide services that honour and support our community.
Thank you very much. Ms Strickland, would you prefer Shelley or Ms Strickland?
Very Shelley.
Yeah, Shelley, would you like to introduce yourself?
I also would like to acknowledge the land on which we're meeting today, the Wurundjeri country, elders past and present, and for your time to listen to what we have to say. I feel it's been a long time coming, so I feel so privileged to be part of this, to be able to give evidence. My name is Shelley Strickland. I was born and raised on Gunarkurnai country. Spent a predominant part of my early years working and being mentored by and really lucky being mentored by some elders, strong, opinionated women that I hope that I do proud. I then went on to work at VARS as the Quality and Compliance Manager, and then on to Wootherong in Family Services, where I have found my passion in working with child protection, family services, perpetrators, family violence, etc. I think that lived experience is something that I want to ensure that is a huge part of where we're moving forward, to make sure that we're accountable for that. And again, I just want to say thank you.
Thank you very much. And Aaron, would you prefer Aaron or Mr. Wallace in this setting?
Aaron's fine. Aaron's fine.
So, Aaron, can I ask you to introduce yourself to the commissioners, please?
Yeah, my name's Aaron Wallace. My father is a Wallace and he's a Wiradjuri man. And I've always, identified as a Wiradjuri man. My mother is a Yoorrook woman and she is a Peters. And I would just like to acknowledge the traditional owners of the lands that you are meeting on today, and also just want to acknowledge that I'm meeting today from Yoorrook country, and I want to acknowledge my elders and ancestors as well, and also my Aboriginal colleagues in the room today. My role is I'm the Director of Child Safety and Cultural Support at the Bendigo District Aboriginal Co-op, and I've been there for just over a year now, and prior to that I was the CEO at Nernda Aboriginal Co-op as well. My background is in the education sector. I started off working in education when I left school, and I also became the youngest ordained Minister of Religion in Australia when I was 17 years old, and I've been working in the community sector ever since. My area at BDAC at the moment is I oversee Section 18. We're fully authorised, and I oversee the access program and all of our child safety programs as well. And I'm really privileged to be here on behalf of my organisation, and would like to send regards from our CEO, Dallas Whitcomb, as well. Thank you.
Thank you very much, all. So I might just come back in case there's anything, Aaron and Felicia, you'd like to say more about your organisations. But starting with you, Auntie Hazel, would you like to tell the commissioners about the work of Nernda?
I'm privileged to work with an Aboriginal agency that's been around for over 40 years. We're a multidiscipline centre, so as with Rumballara, we work from zero to the time that they pass. We have a number of services, and I won't talk about the other services, which is health services, social and emotional wellbeing, youth justice, community justice, Brimba. Brimba's our early childhood centre and our childcare centre. It's the crown in Nernda's, or the jewel in Nernda's crown, mainly because they look after our most precious possession, and that's our children. My service looks after children who are in our out of home care space, children who are unable to be with their family for one reason or another, and also with families that are struggling to keep their children within the home. That's in the out of home care space. We're in what's called pre-authorisation for Section 18, and we're hoping to go to full authorisation by October 23. So, and then the other areas that we work in is that we've got integrated family services, stronger families. Oh no, sorry, we've had a reform. So integrated family services, and forgive me for all these names, but family preservation, reunification and response workers. We have housing officers, homelessness officers, and family violence workers. So in my space, our work is around building the resilience of our families that are struggling and vulnerable and at risk of losing their children, to ensure that they get their children. And if the child's gone, it's about connecting them to the community, because we all know that we grow up strong in identity and culture and on our country. And when the unfortunate, I tend to have so much information, I rush to get it all out and I miss stuff. The unfortunate component of Nernda is that, and we've also got foster care. The unfortunate side of Nernda is that we know that when a child is removed from their family, and if we can't get them family on country and they're removed off country, they don't come back to us until they turn adults. That is crippling for our community. And it's one of the reasons why our community will remain unhealthy when we lose our children. And Yoorrook children, and Felicia can probably confirm this, is the largest cohort of Aboriginal children in out-of-home care. And I think that's significant, and it's a real issue for Yoorrook people and for this community, the Victorian community overall. So our job is around connecting those children and making sure that they're being well cared for, and that they're, that they get to dream and they get to achieve their dreams. When we take on our kids, the first time we took on kids, they hadn't seen a child protection worker for 5 years. And they went from 5 years to seeing a worker every 2 weeks. They actually got sick of us. They said, we're not used to this, but those kids got a concept of additional people outside of the carer and their family that cared for them. So when I talk about the village, I talk about a responsibility for all community members that have around looking after children. Years ago, I can remember, and Felicia can probably, and Shelley and other Aboriginal people in the room can probably remember, when we walked down the street as kids, and if an elder seen us or another older person seen us misbehaving or getting into trouble, they had permission from our parents to swiftly kick us up the bum and send us home. And by the time we got home, our parents usually knew that we'd been up to mischief and gotten into trouble. But not only, so there's that's part of being in a village and having a village being responsible for you. But the other part of it is about, if your family was struggling, if there was a death in the family or there was an illness in the family, the community surrounded a holistic approach and helped you care for your children so that you could heal yourself, or you could do what you need to do, knowing that those children were they were safe within culture, they were safe within that family. So it's a wraparound support. ACOs now function to a large degree. We wrap around supports in regards to the care of our families. So, but in some ways, that concept has been lost within Aboriginal communities, and it's been lost for a number of reasons, because our fabric was attacked. We had kids stolen from us, and we had there's lots of trauma that occurs, and I'm not telling you it's anything different. I'm not sure if I'm articulating this very well. And those traumas have been formulated from things from being stolen generation or from families. If you can imagine what it would be like to have people come down and drill down on you and have your child being removed and you running after that child, and you can see the child crying in the back of the ute or the car, and you're crying as you're running down the road for that child, and you have no power to prevent that from happening. Or even if I take you back further, having babies buried in the grounds with their head exposed so that white people could have a sport and knock that baby's head off. So that level of trauma is infused in our very DNA and our bloodlines. And our people have got to recover from that. And that level of trauma also breaks down that village concept. So for me, Section 18, in our case it's Wolayaka, we call the program Wolayaka, we become that village for those children that aren't privileged enough to have a healthy family. And unfortunately there's more children out there than we would like to count that fits in that boat. They're not in a position where their families can look after them. So from that perspective, we as adults, and being part of an Aboriginal community and being an Aboriginal agency, have a responsibility, a duty to step up and ensure that that child is wrapped around with whatever service that they need to achieve whatever goals they want to achieve in life. That could be a doctor, that could be an astronaut or a teacher, or it could simply be being a loving parent, a loving father, or a loving mother, or good brother or good sister. You know, they set their challenges in life and we support them in achieving those challenges that they want to achieve. So for me, that's what Section 18 does. That's what ACCOs do very well in regards to caring for our kids in out-of-home care and in child protection. The other aspect with Section 18, I am aware that there are lots of community that consider that to be part of, or they don't want to go into that space because of the stolen generation, and that they don't want, because stolen generation is a very negative concept. It was a disempowerment of families in regards to the right to care for their children. And when anything is tainted by that, it becomes very emotive for Aboriginal people. But for me, Section 18 is the fundamental definition of self-determination. What other definition of self-determination is more pure than the right to care for your own child or the children within your community? That's, to me, what self-determination is. And as an adult, that's my responsibility to fill that in and allow those children to achieve their own self-determination by determining what they're going to become when they grow up to be an adult. And hopefully we provide them with enough support to break that cycle where their children aren't removed constantly. Sorry, did I answer your question?
That's terrific. Thank you. Sorry. Can I just ask you about a couple of the services you provide? Are they in and around Echuca, all of them?
Look, when I talk about a holistic service with Nernda, all the services are provided within Nernda. There are some key points, key services that we all struggle to get. Like for instance, you know, we quite often have kids that are, their sexual identity is confused, is a polite way of putting it. You know, when I grew up, you were either, there wasn't an issue around whether you were he, she, or there or them, and I still don't understand that concept, so I'm not really going to. But, you know, it's whether they want to be gay or whether they want to be gender neutral or, you know, that type of thing. And we've had, over the years, we've had a number of children that try to commit suicide because they don't know how to bridge that gap, and they don't know how to identify what they are. You know, Aboriginal people don't actually think of kids in terms of that. We don't think of kids in terms of disability. We don't look at that. We just see them as a child that deserves to be loved, irrespective of what their sexual preferences is, whether they've got a disability. So those kids need counselling and expert counselling, and we can't get that. You know, our best advice from specialists is to take them into the hospital, get them assessed, and when they've tried to commit suicide, that happens, then they say, oh, they're not dangerous enough, and there's no real risk there. That risk is past. We'll refer them into CAMS. You can't get into CAMS till about 3 months down the track. The moment's gone. When kids cry out by self-mutilating or committing suicide or trying to commit suicide or, you know, other threatening people and preventing coming across as violent to other people, that's their cry then. And that's when we need to get in counselling. But not just any counselling, it has to be counselling that's used, that can communicate with young people, that can communicate with Aboriginal people, that understands trauma, that understands the level of intergenerational trauma that we have, you know, because we have, look, I've got a number of kids where people look at them and they say, oh, they're going to grow up to be criminals.
So is that an example, Aunt, of a service that you aren't able to provide locally?
We try to get counsellors in and we get them in, but you can't get it in when you need it.
Okay.
You know.
I just wanted to ask you about a couple of the other services you offer. There's the Barimba Childcare Centre.
Yep.
And do you want to say anything about that?
So Barimba Childcare Centre is a centre that takes on kids from 6 months to the time that they go into kindergarten. So out of there they run a number of services. So they have hearing tests, they have childcare, they have kindergarten, they have bush kinder, they have hearing test, eye test. So all their little milestones, they get in the specialist into that service and they do the test in-house in Nernda. But they also do a lot of other activities. The kids go out in bush. Have you ever seen our kids go out in bush? Right? You see, and I'm sorry I'm a bit croaky. I haven't got COVID. I've come back negative, but I've got some sort of problem with the voice. When our kids go out in bush, right, you see them in the town, they're all like this, jittery, and you can see that they've already picked up from their parents that they've got to observe their environment and find that escape avenue real fast. When kids are like that, the trauma in the brain is constantly working and it doesn't heal. As soon as we take them out into bush, something flows up, something magical happens to those kids. Their shoulders down, and it's not only kids, it's adults too, their shoulders get released. They feel a force that sweeps over their entire body, and that force gives them permission to relax. And I call it exhaling. So once they exhale, then they start to heal. And our bush has magical powers, not only for Aboriginal people, but for everyone that goes out to bush will be aware of the powers that come over them when they're out there. And when they take their shoes off, then their bodies, the force of that land flows up through the soles of their feet into their bodies, and they can run around and be something that they can't be in community or in townships. They can be kids. They don't have to worry about who's watching them. And they can run wild until their little hearts are content. And so Barimba does that. But not only that, Barimba does a lot more than that. You know, if families are struggling and there might be something going on within the families, Barimba provides a safe harbour for the children. So it's an environment where they can come in, they can be kids, they can socialise with each other, they can be introduced to other elders that are safe within community. They learn about their culture, they learn about language, they learn about interacting with each other respectfully, which is all social boundaries that we all need to learn. But they build up their resilience so that when they go home to an issue that might have some family violence, or they might have a grandmother that's not struggling who's the primary carer, they can deal with that. And the level of damage being done to their brain lessens. So Barimba gives them enough strength to come home and deal with that. And when they go back in, they get another dose of that positive outcome. You know, people telling them, gee, you're beautiful, you're a smart little kid, you know. That's so talented, you know, and their eyes light up. Where you see a child that doesn't have access to that, their eyes are dull, you know. And our kids' eyes should always be sparkling because they have so much to offer. So that's what Barimba is. And, you know, I was privileged to go to, what was that, Tracy? It was, I think it was Reconciliation or one of the special days where we went to Barimba and they did a flag raising at Barimba. The kids did a dance, so they had the didge play and the kids were dancing around and then they were singing in language. That, and to see their little faces light up and to observe them, you know, knowing that they were safe in that environment. That was an absolute privilege. All our kids should feel that every single day of their life.
Thank you. Felicia, you've touched on the work of Rumbo. Would you like to say some more about its work and what stage it's at with the Section 18 process?
Yeah, sure. So Rumbo has a really broad service delivery, and it's fairly, it's pretty unique. Working in the space of health, justice, family services, of course, aged care. In the aged care space, we do everything from case management of home care packages to an aged care facility, a 30-bed residential centre. There's only 2 of us in Victoria, so there's ACES here in Melbourne and us in Shepparton. And we also have a palliative care centre there, which is the only Aboriginal palliative care centre in Victoria. Very, very special place. And the staff there, they support families and walk that journey with elders and the families as they enter the dream time. That's very special work. We also have a women and children's accommodation centre, and we're about to trial one of the sobering up centres. So Rumballara, it never closes. There are many elements of the organisation that operate 24/7 every day of the year. We're in the pilot stage of Section 18, so we're in, similar to NYRNDA, pre-authorisation or as if. However, we do contract case management of children and families that come over from the department, and we've been doing that for quite some time. There are challenges with that, but we're looking forward to, going through this journey around Section 18. Like Hazel said, sadly, children on Yoorrook, we have the highest numbers of children in out-of-home care. So there's a lot of work to be done.
Could I just ask you to explain to the Commission what it means to be as if? Is it the same as pre-authorisation?
Yes,
Yep.
yes, it is. Yes.
And how are you managed when you're in that as if stage?
So the department, they walk alongside us, and support us through that process as we start to take on components of Section 18 until we get to the stage where we're very confident of our ability to take it on, that we've put everything in place, that we have all the resources, because there's a lot of stuff that needs to go with Section 18 before you take it on fully, and that's making sure, even that your governance structures are strong and that they're solid and, they're grounded. Your organisation needs to be, and everything you do needs to be grounded in culture, to be able to take something like this on. And you need to have your staff. You need to have all your staff on board without any gaps. And so at the moment we're recruiting, and that's going okay, but that's also challenging because to work in this space you need staff who have strong case management skills and have been doing this sort of work for quite some time, because our families and our children come with complex issues. They've experienced lots and lots of trauma. So you have got to have a lot of skills to be able to support them properly.
Can I just ask, in addition to the trauma, do the kids come with complex medical needs or health needs?
Yes, they certainly do. And I think one of the good things about sitting Section 18 in Aboriginal community-controlled organisations, and particularly those that have got the health services connected to them, you can truly provide that wraparound service, like Hazel was saying. That's really important. You don't want people to families to have to be trespassing all around the town trying to access a service, but also having to tell their story. Everybody is sick of telling their story lots and lots of times to different people. So in the settings of the community controlled organisations, it's vital to have those wraparound services.
Oh, just can I follow up on that? Does that mean you can share information between the different services?
Yes, if you've got the right processes in place for doing that. And that sharing of information. But everybody needs to give permission to do that. Yeah, it's the same as we often have people, they might be a member of the Rumballara Aboriginal Co-op and they may also use the health service and be a client of the health service, and their address on the membership might be wrong, and they'll say, oh, can't you just get it off my medical file? Well, no, we can't, because nobody can access your medical file. So everything is separate, but there are forms for sharing of the information.
Thank you. Shelley, would you like to tell us about GJAC and the work that you do down there?
Yeah, so Gippsland, East Gippsland Aboriginal Cooperative, which is the full name, but the acronym is GJAC, was founded close to 47 years ago by women that felt that healthcare, education and housing were so low that they walked from Lake Tyers to Bensdale to be heard. And I think of that often as to, 47 years later, where are we in comparison to that? And in some ways, we're still in the same spot 47 years later. The growth hasn't really changed a lot. Housing is at an all-time low. It's, we've got homelessness is huge. Our health outcomes are still not at the correct place where they need to be. And of course, education is still something that I advocate for daily, with literacy and attendance in schools from both youth, young, adolescents, all the way through to adult. GJAC covers, like Rumballara and Nernda, covers exactly the same area of services. So we have a health service, we have Dahlia Row, which is our kindergarten and early childhood. We have aged care, although we don't have the services for live-in arrangements, but we have case contracting, we have family violence, out-of-home care, we have women's shelter, which is, something I'm extremely proud of, although still very difficult in circumstances that we actually have it in such high demand. We have youth, so we have what is called Nangara, which is from 17 to 21-year-olds for a 6-week program, although it comes with difficulties, because after 6 weeks, what then happens to these children? And they effectively are young adult children that we then don't have any housing for them to go in, so we create a bottleneck. The one area that I think that I'm constantly battling and advocating for, of course, is, and both Felicia and Art raised, was mental health. And mental health in our communities is so severe. Bensdale is still one of the highest rates of suicide in Victoria, along with Geelong, and yet we're unfunded. So when we talk about what can we do better, we're only just getting funding into our community down there now, and I mean pilot stages, writing the framework. And it's not just to throw money at us, it needs to be a cultural framework. The framework that we're not, doing what everyone's doing mainstream does not work for us as blackfellas. And so whilst I see that 47 years ago, these amazing, strong women that I look up to walked for us, I still think that we're not heard 47 years later to where we need to be. So we offer great services for our community. We are predominantly based in Bensdale with quite a number of sites. But it is a battle every day. I wouldn't say at one point that we're not advocating and fighting. What I will say is that I'm really proud of, and it's exactly what Aunt said, is that we're a village. And, you know, children are raised by a village, and I am proud every single day to see that as Aboriginal people, that cultural village is constantly there. And that might be because of end of life. It might be because children are going into care. It might be because they just need support because of mental health. We are still there. However, it's not recognised. And so that cultural framework in our organisation, we are constantly fighting to be funded for, to ensure that that's put across. And they're the battles. So it does take a village to raise a child, and we are that village, and we advocate for that daily. But is it seen by others? No. So I'm extremely proud. Everything that these both had said, I concur. It's exactly what we're doing, but it's never easy, and it's still not easy. And there are so many things that we are not heard for, and still 47 years later.
Thanks, Shelley. Aaron, can I invite you to tell us about the work of BDAC, or Bendigo and District Aboriginal Cooperative?
Yeah, so the DAC provides a range of services ranging from health and wellbeing, medical health and wellbeing, to community and youth justice, and has just started to enrol for the kindergarten, which will start next year as well. So we're moving into the early childhood space. We also provide, as I said earlier, within my area, a range of programs and services in the child safety space. So obviously Section 18 is one of our programs, which is fully authorised to take up to 108 children within the Jar Jar Wurrung area. And also we provide the kinship case contracting program within my space, and also we provide the Access Aboriginal Child Support, Child Advice Support Service to obviously the Bendigo area as well. So we're within the Bendigo district, and it extends probably down to the districts of Boort, Reedsdale and Creswick. And more than half of the Aboriginal people living in Bendigo are under the age of 24 within our area. So we provide that holistic approach across our organisation, and it ranges as per the other ACOs. We also provide the health services, the community services, and the early childhood services as well for our area.
Can I ask you, Aaron, where are you at in the Section 18 process?
So we're fully authorised and have been for a number of years. We've pretty much got about 92 children authorised to us at the moment, and we have some capacity for some more children. And obviously we go through different processes to transfer more children to us, and sometimes there are some roadblocks in doing that, which is why we're not at full target. But yeah, BDAC's been providing this for a number of years in the Section 18 space.
But what are the sort of roadblocks you're coming across?
Some of the roadblocks are, obviously, one of the roadblocks is around Aboriginality. So in order to transfer children over, we like to be clear on their Aboriginality, and oftentimes the department haven't done some of the work, or haven't been able to get more information about whether a child is Aboriginal or not. At different times, the box gets ticked in terms of within child protection at intake or at investigation phase, a family might identify, but a lot of the times there's some information missing, and BDAC are unable to confirm, some of those links. And at different times, families are unsure as to whether they identify or not. So identification is a really big roadblock for us and some of our families in transferring children over to us. The other issue is that within the division, the Child Protection Division, they may sit with X amount of Aboriginal children, and a lot of those might be interstate or within other areas that we're unable to provide a service to because of the geographical restrictions and our staffing.
Okay, and Felicia, you've had that issue too with identity and confirming Aboriginality.
Yes, we certainly have.
So do you want to tell the commissioners about that, your experience with those issues?
Like Aaron said, we're not able to. It makes it very difficult for organisations to take on case management of children when Aboriginality isn't confirmed. You simply can't do a cultural support plan if you haven't confirmed Aboriginality. And, that there's been lots of examples around Victoria where, where it hasn't been able to be confirmed and children have grown up believing that they're Aboriginal. And when they hit 18 and they're leaving care, they need to go and get confirmation papers to then, access other things. They aren't able to get it, and it causes further trauma for somebody when that's not been able to be done. It can often be when the departments first go in and remove a child. It can be really simple as ticking a box, and that's not good enough. Anyone can say they're Aboriginal.
Can you tell us what you would like to see or things that you think might help avoid these problems?
So I think there's got to be a bit of a system or a process where if somebody ticks the box and says, yes, they're Aboriginal, that then there is additional support and resources available to both, one, in the department, but two, to the Aboriginal organisation to support trying to identify somebody. We don't get funded, and we don't have any funds for family finding positions in the organisation. We've got senior Aboriginal cultural advisors and we have Aboriginal family decision-making convener, but that's a big burden for them to be able to do that. There should be specific funds to support that work, and then and it should then only be for a period of time too. You can't leave a child in limbo saying you might be Aboriginal, you mightn't be, or get to the point where we just can't find it. That's not good enough.
Okay.
Yeah, I'll just finish off. Should the department take more care when, rather than tick a box, actually put in more information about why the family believes they're Aboriginal, so that you at least have a starting point?
Yes, definitely. Well, they shouldn't tick the box at all. But there, maybe there's, some special box there that says possibly further investigations need to be. But right at the start, they're telling people if someone ticks the box, yes, you're Aboriginal. They can't do that.
Can I ask when and how is an Aboriginal child allocated to the Section 18 system? How does that work?
I'm not quite sure. Maybe Hazel or Aaron might be able to.
Yep.
Yeah, so we have regular consults with Child Protection in our division where there is a list of children who are on the system with Child Protection who identify as Aboriginal or are identified as being Aboriginal. And we, obviously, it's based on our vacancies and our capacity, but we regularly meet and Child Protection provide us with the list of children that are eligible for transfer. And that also might mean that, they're on an order where we're able to transfer them. And so we go through that process around, there's a visit to the family and there's a conversation with either the carer or the parents. And, there's a bit of work there around what everybody thinks about this. And then my understanding is that once children are selected, it has to go to the secretary for sign-off. of the department. So our CEO would write to them, and there would be a formal process around approval, and that can take quite a few weeks to get through. And then we're provided with the outcome that the children have been authorised to us.
Auntie, yeah.
Yeah, there's specific orders. So children aren't referred into the Section 18 unless they've got an order, and it's a contractable order. So those are usually care by secretary, long-term orders, permanent orders, reunification, or preservation orders. Is there any other order, Aaron? So once CP's achieved those orders and the court's endorsed them, then they're eligible to be referred into a Section 18 program. And what Aaron was describing was the process that occurs for selecting those appropriate children to go into that program.
I understand.
Yeah.
And the initial description of the person as the child as an Aboriginal child happens at the departmental level before the child gets to you.
Yeah, at intake. Usually it happens. They'll ask, or the person making the referral into intake will indicate, I think they're Aboriginal. As soon as that happens, then an inexperienced child protection worker, intake worker, will tick the Aboriginal box. Once that's ticked, it's very hard to get that unticked. Rather than saying, reporter indicated maybe Aboriginal, need further investigation, as Auntie Felicia said.
Shelley, did you want to add anything to that from your experience?
Did you say that I was just nearly itching in my seat? No, what I just wanted to reiterate was in regard to having Aboriginality, and it's not as simple as just having an Aboriginality, because it's also accepted by community. And so it's really tricky. If you just use your Aboriginality, I'm not saying just anyone can do that by any stretch. You can't. You do have to go through a process. However, what we are finding is that if they're not accepted or known in community around, or because generally all Aboriginal people know all Aboriginal people of sorts, and so it is very tricky as well in that they might have their Aboriginality. In actual fact, they're not, and they've received it through a different means. It shouldn't just come down to one aspect. We need to make sure that their Aboriginality is done through, community, like where they're originated from, etc., not just through paperwork. It's not as simplistic as that when you're an Aboriginal person. I think that's just what I wanted to add into it. It's more than just one tick.
Yeah.
Fiona, can I just clarify? So for Section 18, the investigation is done by
Child protection.
Yep. And the orders are made by the court.
Yeah.
And all of that work to remove a child is done before it goes to Section 18.
That's right.
Okay. And you also talked before about having health services attached. So when this child comes over and you obviously get funding to run Section 18, is there also funding for the health services to have a health model of treatment for these children? Because, Annie, you spoke about the trauma very, in depth. So does it come with the extra funding?
No.
Support? Okay.
So just so I understand, and following on from Commissioner Hunter's questions, you have the referral to you once an order is made in respect of a child, and you've listed the different orders, Auntie, but the other services you provide to community have to be funded from different sources. Right. Is that correct?
And there are certain things that have to be effectively ticked off to be done. So they must have their health check, like a 715 health check, but it's not exactly what you're saying. It's funded elsewhere. So they don't have to have all of that done to then be handed over.
And that in itself's just highlighted a nightmare for Aboriginal agencies, is that in my specific area, I have over 30 different funding sources that I've got to acquit. So it takes up a lot of my time that I could be utilising it on program development. And that's only in one area. And the other areas, if you look at health, education,
mental health
justice,
assessments.
yeah, there's lots of other areas that have the same amount of funding sources that come in. So it's not easy keeping on top of all those different programs, the funding and the outcomes that are expected to be received, and then the reporting back on them. And in some funding programs, it's not that we report monthly, some report quarterly, some report annually, some of them report both monthly and annually. So it becomes an administrative nightmare for Aboriginal agencies to obtain these grants, but if they don't obtain them, they're not able to provide a service. So, you know, if anything comes out of this, if you can streamline that reporting mechanism and how we're funded, that would be fantastic.
So I take it from what you were saying, Auntie, that it would be more effective for you if that reporting and funding was all channeled together.
Yeah. Yeah, or, you know, there was one reporting mechanism.
Yep.
So, because we spend, my area does our chief financial officer's head in, and I can spend a day and a half there once a month going through what I receive, you know, and so that's a lot of time when we could be producing different frameworks for our staff to operate in, you know, and making sure that our clients are, that our staff are dotting their I's and crossing their T's as far as service delivery to our clients, that they've all had their mental health checks, that they've all had the, and I'm not familiar with these, but the 1-5 checks, that they've all been cited. So we have to cite our children once a week. It's very onerous operating in our space across all the different areas that we operate in.
So the resourcing and reporting, are they an issue for other panel members
Massive
as well?
issue. We're exactly the same. Everything that Aunt is saying exactly. We're bound by such strong accreditation, and whilst I, you know, absolutely want to have best practice, we've just been through the accreditation process, and I would go so far as to say that it was the most culturally inappropriate process that I have ever done in my 25 years of working in ACO. As a community member, I cannot believe that the accountability and disrespect for us of what we went through. And I've got to say, from a CEO point of view who had to mentor the staff across and through that, I hope we never have to go through that again. And that was with the regulatory body as well as the accreditation for DFFH, Family Services, so the QIC process. So we have to have that to be able to do all of what we're doing now with child protection. So it's mandated. I'm not opposed to that. What I'm opposed to is making sure that it is culturally appropriate for us to do it and to be able to ensure the safety of our children. We are spending so much time on paperwork and reporting that we have very little time to ensure that there's the cultural overlay and safety of our children that we so strongly believe in. And at what point did it come that we didn't get that say for our children, that it is there? Because I can honestly tell you, I was completely disempowered from the moment that I met with the Deputy Secretary and so forth to the moment that we passed with no not mets. So we did have no not mets and yet completely disempowered through the whole process. So, you know, I agree exactly what Aunt's saying. We need to do something about the reporting and the way that we are made accountable.
So can I just ask you to expand on that disrespect that you're talking about? When is that the no not met assessment, or is it something else?
Well, I guess it's all of that. So it's all the reporting that we had to do leading up to it, and there was an element where GJAC didn't meet their accreditation, and so then they come into us and have a discussion with us, and effectively we have to make sure that we're compliant. We had a 6-month turnaround to make sure that we're compliant, but at no point did they discuss it with us as to was it doable, was it able, and what resources could they do. So yes, they put conditions on us that we had to ensure that we followed and met, and at no point in any meeting with executive director, sorry, I apologise, I speak to the commissioners, did they actually consult with us for our opinion? Could we do it? We were just told we had to do it, and if we didn't, we were at a very real risk of losing our funding, which meant that our services, for the first 6 weeks of that, they actually stopped our service of children because of we weren't regulated. Now, I don't dispute that, but you can imagine our children having to go out to other services. There was no discussion with us about that. They just made that decision. So they didn't say, Shirley is the CEO, the chair of the board or the board, what is it that you're capable or believe that you can do and we'll give you this time? They made the decision for us. And so then, therefore, we had 6 months to jump through every single hoop and to be fully accredited. Otherwise, we were very strongly advised that we would lose our funding. That's not self-determination, and that's not our working for our children. I don't even think that I'm at that stage to actually document it down at how appalling we were treated, to be honest. I don't want anyone to ever have to go through that again. And that's what Aunt's saying. If we don't do that, these are the repercussions. So if we don't comply with everything and all the reporting that's happening, the repercussions are what we've just been through at DJAC. So we're now fully accredited again, and we're now regulated. But they gave us a 6 month window to do all of that, making sure all the governance, service delivery and everything was all sorted with no support from them, just constant accountability.
Felicia, sorry,
Council. Can I just clarify that this is a department that's had multiple changes over recent times, and I think it has another name now.
DFFH right? Now, yep.
Yes. And can you just say what that stands for? Just
Family's Fairness.
Department of Family Fairness and Housing.
Thank you.
So Felicia and Aaron, is there anything you wanted to say as well about what's not working or working for your services with the funding or reporting evaluation side of things?
Well, I actually gave a presentation with VACHO a little while ago around to the Health Minister around the overburden of reporting in the Aboriginal sector, and it's enormous. But what I would like to say in terms of, that funding and support is that we've got to have holistic service and support for children. And every Aboriginal child that comes over from the department that's handed over to an ACHO to case manage should come with a targeted care support package. Every child should have it. It shouldn't just be a specific program for some children, because every child comes who has complex needs. And for us to be able to then link them into all the services that they're going to need, some need counselling weekly before they can, move through that. They're going to paediatricians and things. There are a high number of children that have been diagnosed with things like ADHD and autism, and they are genuine health issues, but I question the high incidence of it in the last few years. We've got little people who are taking medications like Ritalin, and there are cases where, children are acting out because of their trauma that they've experienced. Some don't need to be on this medication. Often the schools and then will place them in, they're too hard basket. They're too difficult to manage. The family unit isn't there. And then they're labelled. And that's wrong too. So there's still quite a bit of work to be done around it. But every child, as I'm saying, they should come with this targeted support package, targeted packages, so that those resources are there so we can put everything that's needed into place to support them.
Aaron, is there anything you'd like to add?
I might just also, I just want to echo what everybody on the panel has shared as well in their organisation. It is the same for us in terms of, the reporting and the evaluation and the piece of work that needs to be completed. It's quite enormous for our organisations to complete, and oftentimes, they're not really done in a culturally safe way, or a way that keeps our culture and self-determination sort of in mind. One of the issues in terms of services for us is around, at times we are unable to get our children into a paediatrician because we have one paediatrician who works across many different places, so is not always available. And then, we had a case recently where the paediatrician was on holidays, and we had children who, had lost their medication, and we needed a script to get them some medication, and they were very high needs, and we were unable to get that medication for them because the one paediatrician was the only person who could approve that script and was overseas, and there was no other paediatrician to contact. So that was an issue, for us. That's happened a couple of times, and that would be sort of an area that, I think, we're given responsibility for Aboriginal children, and they're transferred to us, and we're given that full sort of authority. But at times, as other people have alluded to, we don't have that, this funding to enhance the other services that we have to actually cater for the responsibility that we're given.
I just want to focus now on child protection rather than the other services. The Commissioners are looking at whether the current child protection systems are working. And I wanted to give you an opportunity to raise in any way you see fit your view as to whether the current child protection systems are working, and if not, what do you need to make them work? So, anyone like to kick off? Shelley?
Do you want me to go first? I just want to reiterate on top of to Commissioners about what we were just discussing, just to finalise that. So the way I believe and feel is that we are constantly made accountable and jump through every hoop that we have to for the department, and because we're departmental funded, who makes them accountable? So one of the things that they had said to me was that we give you $13 million to run a service. It's a 3-year accreditation cycle, and whilst I'll put my hand up to say the organisation wasn't compliant, but where's their checks and balances and due diligence to make sure that we are? If you're going to give somebody $13 million, you want to make sure that they're doing what they need. So whilst I'm saying that we don't want to over-report, there's also an element where they've got to be accountable if we're accountable. And it didn't seem to be at any point did they put their hand up to go, we're part of this and we'll walk with you. It was all accusations. So if you want to give an organisation money, we need to make them accountable. As for the child protection, where do I start? So one of my biggest issues with child protection is that, firstly, we need them at the moment until we can come full Section 18 and have the full authority over our children. So we have to work as one. I have to say that there are so many areas that are failing us and failing our children. And again, it's that voice. So they're there and they have to do all their checks and balances and their ticks and flicks, but actually they're not hearing what we're saying. And my biggest issue is that we're the authority of our children. We said it at the beginning that we're a village, so we actually would know predominantly who all our children are. So we know the family line, we know where they come from, the issues that have happened behind the scenes. However, we're not heard because we could give them the evidence and I could go and sit in front of anyone that will hear me, but unless it fits into their box of the way that they want it reported, it doesn't work. So I could say that there is a child that is in severe danger and they'll go, but what evidence do you have? It's almost like they have to see it physically themselves that the child has been perpetrated against for them to take notice. We don't have that authority. We're trying to get it and we're trying to work really hard with Section 18, but we are nowhere near that. The battles that we are finding are constantly there in regard to the safety and well-being of our children, and us as Aboriginal people don't have that authority over them because they are still under the child protection services.
What ability do you have to speak directly to courts, to the magistrates?
Absolutely none. And I think it's one of the things that working in this area for such a long time, I have tried many avenues to actually get through to the courts and the magistrates to even give them some sort of cultural education. So yes, while we have the Aboriginal principles in place, and I'm not saying that they shouldn't be there, they are, I think that they feel so bound, child protection, by them specifically, that sometimes we need a little bit of movement. As we know, cultural law and cultural community are very different. We can't just write things down. We have to be movable, and it's not movable. So if I present to child protection, I can't get to the magistrate in any way, even if it's a written document. It has to be submitted separately. It's not part of what child protection submit because they're effectively the authority. And so for a long time, I became part of the justice in the Rajak and became the deputy chair. Still really couldn't get through to the magistrates. And so we have children that have been perpetrated against in homes that I could give you information and evidence to say that there was perpetration happening, but the principals say the best place is effectively to be back in with the family and the family environment. However, that's not always safe.
I want to understand what you're saying, and I'm not sure
please.
that I do. Are you saying that when you're the Section 18 authority with respect to a child, in a situation where you fear that that child is coming to harm in an Aboriginal family, you can't get something done about that because the department is still running the show?
Bear in mind, we're not completely there yet, so we're at those early stages too. So it's really the process we're up to. But even still at Section 18, we still have to work with the department. And I mean, Aaron would be able to vouch for that. It's still not completely our full authority. So
you're not, even when you have Section 18 authority, you do not appear at court in review hearings and the like.
You get a say, but you still have to work predominantly with.
I see.
Yeah. Aaron, do you have that same feeling?
It's in pre-authorisation.
Yeah.
Pre-authorisation, yeah.
It's in pre-authorisation.
Yeah, that's in pre-authorisation. In full authorisation, we have to do all the court work.
Yeah.
And
So
those
we're
sorts of
predominantly
things.
pre-authorisation.
But in pre-authorisation, you shadow child protection, and it's just still there. They get the final.
They get the final
I
say.
understand. Because if you have Section 18 authority, then presumably you're making decisions with respect to that child.
Yeah.
And if you fear the child is in a situation of harm, then you'll do something about it.
Yeah.
It's still quite strict time. You still have to follow some quite complex guidelines to actually get it across. And then it's that, for me, it's ensuring that the magistrates have that cultural training and understanding and beforehand, which I'm not convinced that they have. So we're still, even at Section 18, you're still quite committed to the guidelines of whatever in place for the Section 18.
At the moment, magistrates are allocated by the chief magistrate, or is it by probably the president of the court? Anyway, there's no accreditation process for the magistrate to be qualified to be allocated to children's work or Aboriginal children's work. Do you see a place for accreditation as being part of that allocation process?
I'd love it. I think that's the only way we can move forward, is to actually do a cultural accreditation effectively. I mean, I don't like that language. It's very mainstream, but effectively I believe that all magistrates need to have that cultural competency and learning before that they can do their findings and handovers. And I think that any of us as Aboriginal people in organisations would love to be able to support them through that. So this is a way that we're putting our hand up saying we would want to support them through that. What can we do to ensure that they have cultural knowledge that is not there now?
So can I just understand, is it the Aboriginal child placement principle that's the problem, or the application of that principle by magistrates who don't fully understand the context of it, or both?
I would say both. Yeah, so I would say there's both areas of error in them. I think that the magistrates are following the child's principle, the Aboriginal children's principles, but there's errors in both of them where we're not able to actually have the authority as Aboriginal people to give that to them, and then the magistrates don't have the cultural competency over the top of it.
And to put it simply, are they not listening to you when they're making their decisions?
Yes, they're not listening.
Council, can I just, and Aaron probably would be able to answer this, just want to understand, even because you've got full authorisation, can the department come in at any time and take the child back to the department rather than be under Section 18? Excuse me.
I believe that would have to be approved by the Secretary for children to be sent back. We've never had that happen to us, and I don't think it is easy for them to just come and do that. I think it would go to the Secretary of the Department.
To get a child into Section 18, it has to go through the Secretary, and to get a child removed from Section 18, it has to go through the Secretary.
Yeah, to transfer them back, yeah.
So my understanding is, and correct me if I'm wrong, is Section 18 supposed to be self-determination?
Yes.
Is it self-determination?
Self-determination by Secretary.
Is it self-determination?
But there's two programs operating here. There's one full authorisation and there's pre-authorisation.
Yeah.
So pre-authorisation walk alongside. So Child Protection still has the ultimate responsibility to sign off all the decisions that are made. Once you go to full authorisation, Child Protection doesn't have a role to play. You take on that role. So they can't make decisions and they can't go in and remove.
But is it full self-determination?
Yes, because we're making decisions around our children and our families. That normally, for instance, we have a different assessment of risk in Aboriginal agencies. So
Can I just ask on that, Aunt? Sorry to interrupt. Yeah. You don't have to follow the risk assessment of the department, or
we follow a risk assessment, but how we assess is differently. For instance, if you get I'll give you an example. We've had a child in our pre-authorisation where under a preservation order to the mother. The mother has lots of trauma and in the space of 3 months lost her mother and lost her grandmother. And so she went totally off the rails, left the child with the father, who wasn't allowed to be left with on that order. Normally Child Protection would go in and remove straight away and they'd do an assessment of the father. The father had some criminal records, so that would prevent the child from going in and being placed with the father normally. At Wallayaka, which is the name of the program, which is a Yoorrook name, but it's the name of our Section 18 program, we went in and we assessed the father and we asked him some pointed questions about what was happening in his life when he had these criminal activities, and we assessed that that he was okay to take on the child. In our experiences, fathers aren't looked at successfully as primary caregivers for children. And in our Section 18, we've had 3 fathers become primary caregivers over the mother in that time frame, because the mother still had lots of issues that she had to have. And we went from a preservation to an IOA, or was it IAO, interim accommodation order. Then to another preservation order to the father. So Section 18 is a form of self-determination, because it means we're making those critical orders or decisions in regards to where that child's going to go.
Can I ask, would that depend on the region you're in and the relationship you have with the department? Could that be a factor?
It does, and that's one of the complexities about working in this space, is that both Aaron and I are lucky to work in the Loddon area, which has had Section 18 in it since VACA, the Newgill program, came on board. So they're used to Section 18, whereas other areas are just learning that pathway. And the other aspect, it's not only in the Section 18, it's in kinship, it's in a lot of things like the child placement area. I find that other areas aren't their approach to implementing the child placement principle is different to what we're used to, because we're very lucky that we've had VACO, BDAC, ourselves and MDAS in our area, so we tend to go in and fight rigorously in regards to it. And I'll give you an example. We had a child that was 2 years old, was placed in the care of her auntie in Echuca, and then all of a sudden, and we were dealing with another division, which is the East Division. They came in and they removed the child, gave them a 20-minute notice that they were coming in to remove the child and placing the child with a non-Indigenous carer that was also an auntie. And they deemed that auntie was more suitable than the Aboriginal auntie that she was placed with, because the Aboriginal auntie used marijuana. And so, but they knew that when they initially placed the child with her, that she was a social user of marijuana after the kids. So, so in one instance that child was with an Aboriginal community, with the Aboriginal auntie in an Aboriginal community, went to school at Barimba for the 2 years that she was on this earth, and then in the next breath she was moved and placed down in Geelong, which is a long way from country for her, with her non-Indigenous family, had no access to her Aboriginal family, and that's not the Aboriginal child placement principle being implemented there.
Thank you.
But that wouldn't stand in Loddon. So there is...
They were two different regions.
Two different divisions.
Okay.
And north and the east. And, and that's one of the problems with having the 4 divisions, is that, we attend the Aboriginal Child Forum.
Children's Forum.
Yeah. That's why it wasn't flowing out of the mouth, was it? And they make decisions at this level, but it doesn't filter down to the operational level as effectively.
Is the forum able to respond when you raise issues of concern? Any of you have a view about?
Oh, look, they generally respond, because the one thing I know about DFFH, they don't like looking at their warts or their warts being exposed. Mm-hmm. Where I'm an accountant background, I love looking at my warts because it means I can fix it and address it. But they'll go in and try and address things so that they look good at that level.
Do others have the same experience?
I would say that I see what Ant's saying, but I would say that they don't address them. Like, they don't like looking at their warts, so they cover it up.
Yeah.
And so that's what I would say. Sorry, Commissioners, I'm looking at the wrong way. So I would say that ACF had the best intentions of when it was set up for, so Aboriginal Children's Forum, which meant that we could go and be at the level we need to be heard. I would suggest that the last 4 we've been spoken to, and there was no interactive, completely run by the department and, attended by ministers, but in a tokenistic way. So, it's effectively Minister such and such is here for 15 minutes. Mm-hmm. That's all we've got. And then off they go, and they walk around and they smile and they tap you on the hand and go, nice to meet you. It's irrelevant. If you want to actually be heard, come and speak to us, but give us informal sessions. So we sit there for 2 days, which takes us 2 days away from our community, and we just listen and be spoken to. And the whole time, it's not interactive. And then we have a dinner, which is a formalised dinner that the minister will come and, again, walk around the room for 10 minutes, smile, and keep going.
Who sets the agenda for these meetings?
Could I ask, if they didn't exist, would you miss them?
No.
Thank you.
Yeah.
To be fair, though, that ACF has driven a lot of the reform that's occurred over the last 4 years. So, the level of transitioning of Aboriginal kids into Aboriginal agencies wouldn't have occurred without that ACF.
So you say the last 4 years?
Yep. Yeah.
So the ACF is a forum that you can raise issues directly with the department and for a few minutes with the minister. Are there other avenues for you to raise those concerns on an ongoing basis, Felicia?
Yeah, and I tend to agree with Hazel. There have been. I don't think there's any forum that's perfect, and but there has been some, good outcomes come from the ACF, and I think it still needs to be and still needs to continue. But another mechanism that we also now have is the Aboriginal Children's Alliance, where all the organisations who are working in this space have got a member that sits there, and that is fully overseen and managed from a self-determination base. It is all Aboriginal CEOs or senior executives in those orgs working in that space, and that's another mechanism now. And we often have input into things that are being put up for legislation changes, and obviously, having input into those sorts of things.
Shirley, can I ask, how could you make it work? What's needed?
So that's the difference. The way it stands now, when Commissioner asked me, I wouldn't miss it the way the format of it is now. And we're speaking at the Children's Alliance now about changing the whole format and looking at the terms of reference and why and how it could move. So for me at the moment, so I agree probably the last 2 years, I've found it very unappealing and spoken to and not interactive. So the 2 years previous to that, you're absolutely right. I do think that we've actually got, and legislation has come through that, and I've done a lot of work in regard as part of the legislation in the Children's Act. However, they've got to change it. I think that's the format. How do we change it so it's actually more interactive? So actually meeting together, as in high-level executives, CEOs and department ministers, etc., is great, but it's got to be interactive, and they've got to listen to us and be heard, not just sit down and they speak to us and tell us all the data. Data is very important. I believe in it, and I think we can't get anywhere without it, but it also not be spoken to about the data. So I could say at the last ACF, there was a conversation about referrals for our cultural support plans, and we're well below, but we're not getting any referrals, and so that's a concern. We've had one conversation since about that. Why is that happening? So it needs to be more outcome-driven, not talk.
And with the agenda, the point I was making before, do you feel that you have capacity to put things on the agenda and have them discussed in full? Or is the agenda more presented to you?
We have the Children's Alliance, which I think is a really good spot that we can get things on the agenda. But again, it is very hard. That it is set a lot. It's run by the department effectively. I'm not sure whether Aunt and Felicia have a different opinion, but I find that they do set the tone and how it's to be delivered. So if I talk about the regulatory body that I have spoken to earlier, there's going to be a new reform on the accreditation for that. There was a discussion at the ACF 2 ACFs ago, but they spoke to us. They didn't ask for any interactive. They want to make sure it's culturally appropriate. However, we've had then offline where we've had communications where it's not one-on-one, it's actually in a group. So it's very intimidating to talk about your finding. I don't want to talk completely about what GJAC's business is in front of everybody, but I do want them to be heard. So in some ways, there's so many of them are tokenistic. Yes, we've had consultations with the CEOs or the executive managers of that area. So they've done that. But it's actually not accessible for us to speak freely in regard to that.
Aaron, can I just bring you in here on the question of the forum and contributions?
Yeah, my sort of feedback on the forums is that I agree that over the last few years the work of ACCOs has been extended, by the advocacy that's taken place at the forums, particularly Section 18. And also, there's a piece of legislation that we're trying to get through to extend ACAC into the investigation phase, so that DAC was chosen to be part of that, and we're waiting for the legislation so that we can actually enter in and do the investigation piece before Section 18, because Section 18, we do great work, but it's too late. By the time we get those children, the family's been through investigations, there's a lot of damage been done. We need to get in earlier, and that's why we agreed to take on this new pilot to actually take on the investigations prior. And which brings me back to the ACF. The ACF, in my opinion, has extended a lot of the work of ACOs and the things that we get to do. However, the data that's presented at the ACF around the work of ACOs has shown that, I can speak for BDAC, our reunification rate is higher than child protection. And if we look at our data versus the data that child protection present, I would say that over the years, child protection's data has gotten worse in terms of working with our children. So my reflection is that ACOs, the data, shows that ACOs are doing really well in this space and are advancing in this sector and are getting great outcomes for our kids. However, it has not increased how child protection work with our children in their system. So there is a focus on, let's resource ACOs, but not every ACO is a Section 18 ACO, and the substantiation rate across Victoria for Aboriginal children versus non-Aboriginal children is so high, and that data has shown that more and more of our children, the data we get at ACF, more and more Aboriginal children are entering the system than ever before. It's not getting better, it's getting worse. And when we do, say, this needs to be done, that needs to be done, this is our feedback, and oftentimes we do get a blanket statement saying, we've got a lot of work to do. I could probably tell you, some of the general statements we get back at ACF that the department make about we've got a lot of work to do, that's something we need to consider, let's take it offline, let's go back to the division. And we're just sick of hearing that. We want to see change, and we want to see that rate come down. And it comes back to, ACOs are expected to perform and to get results, whilst child protection are allowed to just allow the data to get worse.
Can I just ask you all, are you all seeing a positive result in terms of your work, in terms of the rate of removals and the rate of reunifications compared to mainstream department results? You all seeing better outcomes for kids?
Yes, I think there's clearly a lot of data around, particularly for those orgs like VACA, Bendigo, DAS, who are already in doing full authorisation. The reunification numbers are quite high, and they've had a lot of success. I mean, I'm really looking forward to that. I mean, the challenge across Yoorrook, Waka, there's so many children in out-of-home care across there. That's what I want to see. That's why we're signing up for it, because we want to see reunification happening. And also that when all of these assessments are done, they're done by us with an Aboriginal lens across what we're assessing. Because that is one of the other problems, is this white lens is used to assess everything. And often that white lens is grounded in a basis of prejudice and racism, and unconscious bias. It's there, and there are lots of examples of that.
You go into this in your statement. This is an important subject to us, and you give some detail in your statement that goes beyond other statements that we've received, and I congratulate you on thinking about these matters. I wonder if you could give us some examples of the kind of bias that you think affects decision making in an unfair way towards Aboriginal families.
Okay. So recently we have a carer down home there who's been caring, is a permanent foster carer. She's been caring for kids for quite some time. Anyway, she's got 2 or 3 kids with her. Recently, a new gung-ho child protection worker was engaged to support one of the placements there, and she had a little bub placed with her over 12 months ago. Rang up very, short notice, emergency, can you take this baby? Yep, she said. So they basically, so the department have placed the baby with the foster carer. She's Aboriginal. And nothing else. No one's been back. Over 12 months, nobody's been there to visit that baby, nothing, to visit that foster carer, see how she's going. All of a sudden, as I said, this new gung-ho staff member come in, and she starts making contact with I want to come around and visit. Okay, and the foster carer tried to negotiate a time, can we do it here, blah, blah. Anyway, they finally get to a visit. She comes there and, her first comments are, this house is dirty and your lawns need mowing. And then she sent her texts, I'll be back next week to check. And she was sending to the foster care, other lawns being mowed. I'm quite, I'm escalating this up. I have concerns that the child's at high risk. There's nothing wrong with your lawns not being mowed. That doesn't mean that child's not being loved. There was no cot or bassinet or anything provided to her. She's asked for that. It's been knocked back by the department, so Rumbalara's going to have to, we've got to provide it out of our own funds, which we're happy to do, but that's not the point. They've placed the little one there without the adequate supports. And, this gung-ho child protection worker, in her mind, she thinks that house is dirty. Well, we've had our own staff go around there and have a look, and we personally know the foster carer. The house isn't dirty. The house is cluttered. It's not dirty. That doesn't affect her capacity to love and provide a safe environment and care for that child. It's in this background. They're making this assessment. All blackfellas are dirty. That's not. We've lived with that. I grew up with that. My mum never let us. We didn't have any non-Aboriginal kids come around after school and play with us unless we'd cleaned the house, because this is the generation my mum had grown up in. Oh no, because these fellows will think we're dirty. If the house isn't clean. And mum grew up. They grew up on their hands and knees, polishing floors and things. That's no good. We don't need another generation like that.
Yeah, did you have a question?
No, I was just thinking about a break.
Oh, sure. Should we have a 10, 15-minute break?
Okay.
15 minutes?
15 minutes, yes.
Thank you.
Council.
So we'll just make sure we've got Mr. Wallace back on the... There we are. Okay. I just wanted to... would you like to join us at the table? No. I just wanted to draw out some themes that we've talked about generally this morning, or that you have talked about this morning. And one of those themes is obviously the primary principle that whatever occurs to a child is in their best interest. And the other is an important principle of self-determination. So I wanted to throw this open to all panel members, and you may have different views and different experiences about this. Is Section 18 the best way to go in terms of outcome for children and outcome for communities, or are there other ways to go? Are there other ways, non-Section 18 ways to go? And as you're answering those questions, you might like to think about, how do you improve it so it is the best service it can be? What do you need to have the services delivered the way you would ideally like to see them delivered? So I'll just throw that open to anyone who'd like to have a stab at it. Yeah.
I'm happy.
Shelley?
I'm happy with that. Thank you for that. I'm very torn, I have to say, and I know in that stance it's quite political to be torn in that, because Section 18 is meant to be for true self-determination. I've worked at lots of different orgs, and my true belief is children's safety, coming from the world and the life that I've lived. I have seen lots of, when I worked at Geelong at Watherong and I was their executive director there, we were very adamant that we were not to go down the Section 18 pathway, and for the reasons were that if you are the face and you're the ones, that's true self-determination, you can also get a lot of backlash in community, so you can lose faith and confidence in them because you're meant to be there. And so whilst there is the reunification, and we have got high data that there is families being reunified more than in the mainstream services, it's still a risk, and it's an educated risk that you can create the backlash, because community don't always stop and self-reflect and see that. They just think you're the ones that are doing the removal or taking the children away. So it is an educated guess. Do I think that we could work better with child protection and the magistrates? Absolutely. So whilst I endorse Section 18, and GJAC is one of the ones that have accepted that and are doing that, I think that we've still got a long way to go. So I am one of those people that debates it for and against, for lots of reasons, for the safety of the children. I'd like to see that we do have a better relationship with magistrates if we're not Section 18, and therefore with child protection, because the Aboriginal principles are that child first predominantly, and I find that if we can't get heard by the magistrates or work alongside child protection in the correct manner, then they are not hearing what we're having to say. And again, I'm probably that one that does also debate that too. There's times where I think, I loved what Felicia said about, don't judge a book by its cover effectively. Don't look at our lawns and our houses and think that we don't love our children, because that is not relevant as to whether we love our children or not. What I will say is this, is that also, just because the principles state that children need to go home, make sure that they're safe before they go home. Don't just put them back because the principles stipulate that that's the best place for them. Make sure that if you are aware that there's some perpetration going on with our babies, that you're making damn sure that those houses are safe to go back in. And it is, over a long period of time, it is evident to me that magistrates can have seen that children are unsafe, but they send them home anyway. And that absolutely sends me spare. The fights, arguments and documentation that we've put in place to get to magistrates to say a child is unsafe back in their home at that point is huge. So we need to make sure that they're actually checking that, doing all the balances and making sure that those children are safe to go home at that time. So I'm not saying there can't be reform and there's not, supports in place that we can get those children back into the care of their families, but sometimes it's not always the safest place. And who says that? Because realistically, when I sit around the table, no one wants to hear that from me. They want me to say, absolutely, a child should go home tomorrow to that family. It's not always safe. If the home is safe, absolutely. So I guess I'm a bit...
Shelley, can I just ask if that's okay, Council? If it wasn't safe, you would do the planning. The planning would still be there to make sure it becomes safe and you could still reunify. No.
Absolutely. I'm not saying it's non-reunification. I'm just saying they don't go home. If there's perpetration in the home, whether it be whatever form, physical, verbal, sexual abuse, they don't go home until that's been sorted out. There's been planning in place. So it's not an instant non-reunification. I'm just saying that what I see more often, and the work that I've done, and I have been at a very service delivery level as well, that children are placed back in the home because it's the fear of removal, the fear of the backlash, and I find that is very frustrating. And children in severe trauma-based situations are being placed back in homes that are unsafe. Not everyone here. I'm just saying that we need to be really aware of that.
So there's been, sorry.
No, I just wanted to, because what I'm hearing, and correct me if I'm wrong, is that the area you're covering is probably different to Felicia and Auntie. So they're different. Am I hearing?
Yeah. I think we all need to. Yeah. Right.
It's about the place-based type areas of what's needed could
Exactly.
be different.
So everywhere is different, and yeah, the needs are very different.
Thank you.
So does that suggest that there needs to be a focus on what the different areas need and what the families need in terms of their wraparound services as well?
Yes, I don't think it's a one-stop shop. Like, I don't think it's, that's what we're doing for all Aboriginal people. I think we have to be really clear about that and have to look at it as an individualised capacity.
Yep. We've heard some evidence that suggests there might be some risk aversion coming from the department in their processes, such that more children are ending up in care, as an example of, an explanation for why the numbers in Victoria are so high. But this would be an explanation as to why those individuals were risk averse if they have a concern about serious harm. So how do we navigate that as Section 18 organisations or non-Section 18 organisations when you're taking that burden on the organisation and the community might criticise you, as you've said?
Look, I don't know that I've got all the answers, but you're right. It is very hard because either way you look at it, there is criticism. So I think that it has to be reflective of the community that you're from. As both Felicia and Art said, it works really well for them. But if I looked at the other areas that I've worked, they were very adamant that they wouldn't do Section 18, which is actually against what the department is actually saying. But I think we have to stay, if we get a choice to speak about it now, we have to say that. Like we get one chance to talk to you guys effectively as the commissioners to go, it's not always as simple as one model fits everything. And I think you're absolutely right. It is hard to be the voice and stand up and go against that. But I just want to be clear that, yes, there are repercussions both ways. So, I think community can effectively come at us as Aboriginal people if we're the ones in Section 18 having that full authority. And that's a concern because we want it to be also a safe place. Our ACCOs are a safe place. It's their home. They've been brought up there as well. So, I'd be really interested to hear, what effect that has on Aaron, for example, who is a full one, and has there been repercussions around that? I just don't think that we're completely there yet.
I should note, before I ask Aaron to respond, that Ms Cavarilla's joined us at the table for the stage. So, Aaron, would you like to jump in on that and that question of whether Section 18 organisations are the way to go, whether there are other ways, and if Section 18, what do you need to have it work?
I believe that Section 18 is the way to go for our community, and that's something that it's not just my opinion, but it is it has come from our community. Not to say that we haven't had any backlash for decisions that have been made, or obviously when it comes to people's children, it's a sensitive issue, and it should be for our community and for families. So I think I remember Auntie Hazel saying, I used to work under Auntie Hazel a number of years ago and learn a lot from her, but I remember back then the CEO at the time approached Auntie Hazel and said, what do we need to do? How can we stop the department from removing our children? Just take them out of our community. And, back then we didn't have Section 18 and we had case contracting, which had no decision-making really whatsoever. And Auntie Hazel's response was, we can't do anything. We can advocate and those sorts of things, but we actually can't do anything because it's not we don't have the authority, and a lot of work since then has gone on around Victoria, and we now have that responsibility and that authority. I think someone has to have it, and it's better to be us than the government, I believe. And so I think it is the way to go. Someone's got to make decisions about what happens when our children are unsafe or are safe, or their safety is in question. And I think there is no better person or group of people to do that than the local Aboriginal community, which is what we represent. We're an Aboriginal community controlled organisation. It's not myself. I'm not the maker over all things to do with safety. That's a team effort. But also our board that have allowed us to take on this program and they're elected by the community. So I believe the model is self-determination. And some organisations, part of that self-determination, decide not to take on. But that self-determination, and self-determination is not always clean and pretty and wonderful. There is an ugly side and a hard side to that, where decisions are made, but they're made by the community, or they're made with the best interests of our children. We've had to make decisions to remove children from their parents in Section 18. And some parents have questioned, where's my self-determination in that, and my decision-making in that. So there's not always a pinpoint to it. But I know for our organisation, in our experience, most of the time, because we have that, we relate differently to our parents and our families, we're able to explain and we're able to walk them through that. For BDAC Section 18, we've had no contested matters at court whatsoever since the program started. And we've been able to work really, really hard with our families. So I think Section 18, is the way to go. If not us, then who? And I think that the Aboriginal community will be making decisions about Aboriginal children.
What else do you think you need as an organisation to have those successes more often? Is there anything that you would ask for on your wish list to set you up for success?
I think it's a bit of a contentious one thing, and I don't know if the other panel members would agree, but BDAC's already going down this path, so I'm not sort of talking out of school or anything, but we have, lined up for the investigation phase pilot. And we're waiting for legislation to approve that. We would then respond to notification. So if a notification comes to Child Protection about a family, we would be and have the team, and we've already recruited the team, to respond to those reports and investigate those reports and make the decision as to whether, that's substantiated, or whether there needs to be some support for that family, and whether there needs to be a protection application. And some ACCOs will probably, like I said earlier, in the interest of self-determination, some would say that's not us. But for BDAC, we have said we want to get in before they're on an order, because by the time they're on an order, it's a bit late. We want to get in when the report comes in, because we know that a lot of the families that end up on an order shouldn't be on one because of the bias in those investigations and because of the lack of support and links to culturally appropriate services at that investigation phase. It's okay that, at times Child Protection will investigate and refer our families to services. Those services are not culturally appropriate, and then they substantiate harm because they haven't engaged. Who would want to engage with, as an Aboriginal person, why would you want to engage with a racist service? A service that's biased towards your culture. So we have some families that, they enter the system, and they shouldn't enter the system. And so that's why we've taken on that investigation phase, because we want to get in early. That's the addition to our service, speaking for BDAC, as part of what our community wants to see. We want to get in early. We want to assess the risk before and avoid having kids enter the system, if we can. If there is harm, then there's harm, and we'll work out how we can work around that. But oftentimes it doesn't need to result in removal. However, BDAC have had to remove children from the care of parents, and that's the ugly side, where I think, for us, we're acting in self-determination as a community, as an organisation. For the parent, they feel like, that's not self-determination for them, and sometimes that's the ugly and hard side that we have to face every day.
Felicia and Auntie Hazel, can I ask you about that issue about the Section 18 and what you need for success?
Yeah, I think one of the what needs to go hand in hand with Section 18, because it should be grounded in self-determination, and there's enough evidence there to see with the VACA model and Bendigo's, that reunification data is really good, and that's positive, and that I'm keen to see that happen too. But we've also got to be funded. So that's the crisis stuff. You know, when they're coming across from Section 8, that's a crisis. We need early intervention and prevention money. So the same investment that's put in there at the end has to go in early in the start. You know, they're starting to fund these places like early years centres where you put a whole heap of wraparound KMS programs, maternal and child health, mums and bubs programs, all at the start. We can identify. We've got Aboriginal elders advisory groups, that come in at that stage. We can identify families right there and then when you can see there's potentially might be, mum or the family's going to need some supports. You can start putting them in there so that before they even get to this other end.
I agree.
All the supports are there. Every community wants strong, healthy families. Nobody wants to see this. And we all want that. We want all our families to be prospering, and we would never put children in a family where we think that there's a risk. We're the most accountable fellows going in our organisations. When you talk about, earlier we were talking about, accreditation and, I know we have to do it, and it is, and we do it. And we've got so many accreditations here at Rumballara because we're doing primary health, we're doing aged care, we've got the Youth Act. But I tell you what, the most important accreditation to me is when an elder or a community member comes up and says, thank you for the service that Rumballara provided me. That's the most important accreditation to me. Tick from my mob to say, the service we're providing for them, because it's for them, it's theirs, is good. That makes my day. That's the biggest accreditation as a CEO that I want.
Auntie?
You might get an epic story here. Sorry for a thing. I think Section 18 is important to communities for a couple of reasons, and we talk about self-determination, right? Years ago, I watched a video called First Australians, I think it was, and had different series and different Aboriginal communities and the impact of white Australia coming in. And one of the stories was from Corondoc, I think, and I can't remember the elders that they were speaking about, but it was a story about Corondoc, and they built up their beer companies that they made a successful business. And then to break that community down, the government went in and removed the children. And it was a story about mothers writing to the government of the day, asking for permission to see their children, which was really powerful, and the language that they used was eloquent and more eloquent than any Australian, non-Indigenous Australian that I've ever heard speak. And they were refused because they couldn't teach them how to be good little white Australians. And if I reflect on that, in those days, Aboriginal people were fighting for the right to look after their own children. Isn't that what Section 18 represents? We talk about stolen generation, and that's an emotive term utilised by certain people within community to say we shouldn't be entering into Section 18 because we're going to be part of or forming part of the government structure that started stolen generation, and we're going to continue working in that space. I think what most people don't understand is that we don't actually remove children at Section 18. They are removed by the investigation response once there's a recommendation. We're not in that area yet. I have a different view of whether we should be going in that, and I'll talk to that after that. Once we receive children, and what a lot of community members don't understand or probably don't actually verbalise it and they don't bring it to their mindset, when child protection goes in and removes, they can, that child protection, they removed my kids. Don't know why. you know, it's probably just a white thing. But when an Aboriginal agency goes in and says to them, and if they're in our programs, we're hearing that there's some issues with the child, with the child and the care of the child. We're looking at that risk to determine whether there's sufficient risk to remove that child. When an Aboriginal agency does that, then they can't blame it on the white sector. And people within community better step up, because we don't go in and remove lightly. We go in and remove when there's real risk. For instance, we've had to remove a child when there was a threat, when there was a likelihood of sexual exploitation happening on that child. That's a real risk, and that child's important, and we needed to go in and protect. We don't make any apologies to anyone in regards to that. And we investigated as fast as we could. And we went through the processes. Like, we didn't determine it. We referred to Socket, and Socket investigated those processes. We've gone into and most of our removals have been with carers, not with parents. I think we've had 4 removals with carers and 1 removal with a parent. For instance, we've gone into a carer and we said, you know, we noticed that your grandchild is actually roaming the streets. It's been observed a number of times down at Coles or down at McDonald's, and these are 8-year-old children, talking to a known prostitute with one of her Johns there. So there's a real risk there that child is being exposed and potentially exploited. Can you tell us why that's happening? And they just say, we were having a drink. We didn't realise they were going down there. And, you know, we passed out. And so, you know, then we have a conversation around, you know, in your family, you know that there's been, or in community, you know that 90% of the time when a child's been exposed to sexual exploitation or been abused, that occurs by a family member. And if you're partying on and you're drinking, or you're allowing a child to have exposure to people that you normally wouldn't allow because you've been drinking, that creates a risk. And, you know, for that reason, Auntie or Uncle, we're going to have to remove this child until we actually work with you to address that drinking problem. And we work with you on developing strategies to support those children when you want to go out and have a social drink with your friends and families. So, you know, and they acknowledge that we have to do that. And the problem with that is that people within community can't blame it on the whites being removed. They have to face the fact that there's potentially a reason for someone that they know within community for that child to be removed. They can't whitewash it anymore, because we don't go in and remove for any reason, you know. So I think that's one of the factors that influences whether communities want to go into it, whether they articulate it that way or not, and they articulate it as a fear from historical events that the kids are going to be removed and it's part of the stolen generation. It's not that. It's the fact that they're being exposed by an Aboriginal community member that says that their behaviour isn't protective enough towards their own children, and there needs to be some protection there for those children. And that's what a village does. It steps up and it protects those kids, whether it's easy to do that or not. And it's not easy. But those children have a right to have a community. It stands up and says, you are important, we are here, and we hear you. And it's our job to look after you when your family can't. And they can't always do that. That doesn't necessarily mean that they can't correct the issues that they're facing. And we can walk alongside them to do that. We've had another, in Walayaka, we had a father that would slide, he took on his child. He had a beautiful relationship with his child, and he could read the child on what her needs were, better than any mother that I'd ever seen. But every now and again, the mother would come back and it disrupt his whole lifestyle and he'd slide back into old habits. So we'd have to go in and remove that child for a little while, or we'd have to go in and put special protective measures in with that father to make sure that he was able to work on what was going on in his life that made him slide back. And we did that over a space of 12 months, 5 times with that father, and each time the mother came in, he had a little step backwards, and those steps become smaller and smaller, and the length between the times that we needed to intervene with that little girl and put her up in a circumstances where she was protected became less and less, to now that we're closing on that father. So, that's, and that's one of the aspects. The other aspect is that, kids that are in non-Indigenous placements, they lose their culture, they lose their identity. And when Walla Yakko comes on, we make those carers expose their children to the kids that they're caring for, to their culture and to their identity, because we, as Aboriginal people, know that if our kids don't grow up within culture, they don't have an identity, they always come home to us, eh? White government or department can take them away for so long, but when they age out, they come home to us. And then they come home to a foreign system that they're not able to relate to, and they get themselves into trouble. They can't identify who the high-risk community members are, and they usually get involved with those high-risk community members. Thus, you have youth issues. And those high-risk community members, they know that they're vulnerable and they exploit that fact. Am I going right off topic here?
No, it's perfect.
No. So, for us around providing a holistic care for our children, there has to be healing practices that occur. So, things that take kids out onto country a lot more, so camps that are cultural. Some of our education system needs to be adjusted to reflect, to happen within, the forest and on country, because that's where our people learn. We don't learn in a classroom. And the other aspect, if I say that, everything that Aboriginal people have been asked to do has been asked of us with an overlaying white lens, non-Indigenous lens, which places us at a disadvantage, because that's like putting a square peg into a round hole. You can't do that, and it's not successful. And then you have the other thing, look, we gave them an opportunity, they failed. Well, you didn't give us an opportunity. It was like asking a man to be a woman for a day. The whole Venus and Mars concept. So for us, there has to be more community practice, but not only just for the kids, but for the whole community. Some of the best programs that I've observed have been those cultural activities that occurs on weekends where families are asked to come out and camp, and they get to tell stories. They sit around the campfire, they yarn, they take away the telly, and they start yarning. They fish and they hunt, and the women gather, and or the kids will cook with the grandparents. Those type of days where we come together as a group of people, respect, have lots of culture, teach kids, show them which country they should be walking on, which country they shouldn't be walking on. Those are the type of healing programs that are sadly lacking within things. Also, you look at the education system. The education is a classroom. You sit in a classroom, the kids are there for how many hours in a day now? 8 hours. That's not helpful for Aboriginal kids. Our Aboriginal kids are designed to be out in bush and running around free. you'll see them in the classroom, they're like this. Or if they're not like this, you've got no visibility of a human person being there because they go off somewhere. Their eyes become clouded and they're not engaging. And, you know, the education system, unfortunately, has failed Aboriginal kids in out-of-home care and still continues today. And especially if those kids have disabilities, you know. I know of several kids that go to school who are deaf, but they don't get a hearing aid person, a translator there. So they're sitting up school, can't hear the instructions given by the teachers. The teachers then wonder why they throw everything up in the air and walk out in frustration. It's because there's no one there translating those instructions by Auslan to them so that they can engage in that practice. Those type of things still happen on a day-to-day basis for our kids. What else was I?
You wanted to mention the training, the challenges for the staff.
I think some of the challenges, and it's not just only in the Section 18, but also in kinship. When I first started this business, I came from an accounting background and I went into a community services background. But I was good for it because I'm used to change management. In my previous organisation, we would go through change management every 3 years. It would take 5 years to roll it out, but every 3 years there'd be another legislation change and we'd have to do that change. So I was able to adapt staff to the changes that we had to go through from a 5-person position unit to a 30-people unit. So there were significant changes, and also some of the requirements around, you know, we're dealing with the most complex children that you can potentially deal with. We've constantly got to talk to people who look at a child that's misbehaving and even in the school system, and they're saying, oh, they're a naughty kid, they've got no boundaries. And I said, excuse me, they're not a naughty kid, they're a kid with trauma. What you're observing is trauma behaviour, not naughty kids with no boundaries. You know, these kids are so used to being rejected that they reject you, or they force you to reject them before you actually do it, because they think you're going to do that anyway. So it's a protective mechanism for them. And the other thing, so our staff need to be highly specialised now in how they work. And not only that, but we need to have staff that are specialised in interviewing children with sexualised behaviours. You know, that's a skill, especially if we're entering into the Section 18 space and child protection steps away. That's our responsibility to do that. And I'll give you an example of what happened to us and there needs to be a process that transitions the clients over fully, where the organisation is fully informed of what's happened with that child. You know, when I was new, I took on a family and they said, oh, the children have been exposed to sexualised abuse. Now, I come from a family that was loving and caring. The concept of abusing a child or sexually abusing a child wasn't in our vocab. So it just didn't translate to me, and I didn't take it on as a mature woman, that's what's happening. My daughter worked in that space, and so I sent her out and I gave her these clients as the first set of clients that she was going to take, and they went out there, and this was the first, and she's black. I'm not, some people call me chocolate, but she's black, so darker than Felicia, to give an idea. She went out there, and these kids that had never engaged in Aboriginal culture before, seen this black girl, proud, strong, takes up a space, walk into the room and say, I'm your carer. You know, I'm your worker, I'm here to work with you. So automatically they had a connection, and these are kids that had never been indulged with their culture before because they didn't know what that looked like. And then she brought out this genogram. She said, I sit here, you sit there. So not only was she black and strong and powerful, there was a visible connection that they were somehow related. And as soon as that happened, those children got diarrhea mouth. And all their experiences, they told her all their experiences explicitly. So she knew how many times that they'd been violated by their family member. You know, what that looked like. They were very open and frank with her. When she come home, she broke down crying. And I'm sorry, I tend to do this when I get emotional. And she broke down crying because she'd never been exposed to that. And it was unconscionable for her to have children who were exposed to that level of abuse. And we didn't prepare her ready enough to go out and be exposed to that. And in her private life, all she's had around her was a mother that was, you know, you got to go to school, you got to go to university. And a father that loved her and her grandparents that loved her, that she'd never been exposed to children being abused other than setting boundaries or expectations on what their education is going to look like. So I think there needs to be a better process when we're handing over families from child protection to our workers so we fully understand the level of trauma that those children have been exposed to, but not only to prepare our staff, but also to ensure that we have the services lined up to better provide a service to those children. Those children now, the other day they hadn't seen my daughter for a while. Next thing I turn around in Coles and here's 5 kids accosting her with arms, wrapping around her and saying, "Jipper, we haven't seen you for a long time. Where have you been?" She hasn't worked with them for 3 years, but they still remembered the love and care and connection that she'd put into them. You know, and that happens on a daily basis in Section 18. But not only does it happen on a daily basis, we don't have white people making, I'm sorry to use that term, I usually refer to non-Indigenous. We don't have non-Indigenous people making those decisions. The only people that can correct what's happening within Aboriginal communities is Aboriginal communities themselves. And that's why it's critical that we get Section 18. And I agree with Shelley, some communities might not be at that stage where they want to take on that program. That's fine. They might want to negotiate with a program closer to them to say, will you care for my children? And that's fine too. We can work around that. So, So for me, that's what makes that Section 18 such a critical program. Now, as far as investigation and response, to some degree, I agree with Aaron. You know, we need to get in a lot earlier. We took on a pilot program, which was a CP diversion AFLDM program about 12 months ago. And when we looked at the data, so AFLDM is Aboriginal Family-Led Decision Making, there's a legislative requirement that families are referred into AFLDM so we can find families that the children can be placed with. That we wanted to pilot getting that program earlier than when it was substantiated, that when the grounds for removal were substantiated. And the data there said that there were 80 families going through the system at any one time, so in Yoorrook country. So we should have met our targets of 35, but within the space of 6 months, those targets were all being referred into child protection. I think the last data I heard, they had 200 contacts on a weekly basis. That's a significant amount. Now, that wasn't broken down into Aboriginal kids, but if you look at the fact that our Aboriginal kids, a majority of kids being referred in, then it's not unrealistic to at least expect half of those families, 200 families a week, are Aboriginal on intake, you know. So I believe that, you know, we should also look at investigation and response. the problem that we have is human resources plays a massive factor in this, and that not all communities will have the human resources to run a Section 18 program, as well as an investigation response, as well as kinship, as well as the other programs that we run, given the level of complexities that we've got in those programs, and the fact that a lot of the programs now and a lot of departments are moving to a level of qualification of people employed within our space. So, I'd like to see a lot of more. And the other beautiful aspect about Section 18 is, yes, we have frameworks within the legislation that we have to operate in, but how we operate in that is our decision, and the cultural lens that we apply to that is our decision, and how we assess that risk, and whether that's a risk that we're prepared to take, that's our decision, rather than a government department making those decisions and saying, this is what we've determined, you need to work within this structure.
I'm going to ask the commissioners whether they have any questions, and then invite you if you want to say anything by way of closing. So I'll just throw to the commissioners if there's anything arising.
A question for Aaron. You talked a little bit more about an investigation phase pilot, and you said it needed legislation, if I heard you correctly. Can you just explain that a little bit more for me? What's happening and what legislation is needed?
It's an amendment to the Children and Families Act that hasn't made it for the sitting at Parliament, and there's been a few, I don't know what the correct terminology is, but they've had a few sittings and it hasn't made it to the top of the list yet, and they're saying that next sitting it should make it there. It's a piece of legislation that we've worked on as ACOs across Victoria, collaboratively with the department, and it changes it extends Section 18, and it extends the decision-making authority that the Secretary can give, and what it will do is will give ACOs the authority to investigate reports as opposed to the child protection. So ACOs will be funded to investigate concerns that are reported to child protection, and will make those decisions around what needs to happen next with those families. And so we're waiting for that to come through, and it's been a long process. And we were hoping that it would have started over a year ago, but because of the legislation, we've been held up. We've recruited staff are trained in forensic interviewing and sexual abuse training and all of those things. We've written our manual. All of those things are ready to roll for us to take on our first home visit. But it's the legislation that's being held up.
Thank you.
Can I just add one thing? There's another piece of legislation that needs to change as well for Section 18 to operate effectively. A few years ago, the government went to and changed the legislation so that if a child's on a preservation or reunification order for more than 2 years, those orders, and I'm not too familiar with the exact terminology, but those orders are lapsed and they go to care by secretary order, because they won't keep them on those orders where where there's a likelihood that they'll go back to the family for longer than 2 years. In Walayaka, we would like to see that change, which will enable us to work with families for a longer period of time that we feel reasonably needed to get those families back into any healthy condition, that's the wrong word, but where they can take the children on permanently. And, because, and the reason I argue that is because this trauma has been around for 200 years, it's developed and it's accumulated. It's not going to be healed with it. Families aren't going to heal themselves within 2 years to be able to get themselves to a state where they can take on the children on a long-term basis. So if we're going to give families a real opportunity in the Section 18 process of getting their kids back, we need those sections that says that we can only have them on a preservation or reunification order for 2 years reversed to enable us to work longer if we think that the family are actively working towards getting their children back in their care.
Auntie, is that their permanent care after 2 years? They can go on permanent care orders?
Yeah, look, I can't remember the full...
Yeah, we spoke about it yesterday. I think it's...
Yep.
The others are nodding.
That's
Sorry.
what happens. Yep.
Yeah, thank you.
Yeah. So it flies in the face of the fact that we're happy to work alongside families that may slide back. You know, the trauma that they've been exposed to takes a lot longer than that to address.
Yes, true.
Can I just also mention that I think I completely agree with what Aunt's saying about we need to be, Section 18's at the end of it, we need to be proactive. So we need to be not reactive. So we need to start working with families really early on before we get to the stage that Section 18 effectively, or not Section 18, the department, are involved. And the other thing that I think is really relevant is that at the last ACF, there was discussions had and endorsed by VACA that as it stands now, you have to be an Aboriginal CEO to be Section 18 of an organisation to have Section 18. But they're bringing it in that you don't have to have an Aboriginal CEO, which then goes against what we're trying to say about true self-determination of Aboriginal people. So, you know, we need to continue. If Section 18 is how we're going to continue and develop and make sure that we have true self-determination for our people, Aboriginal voices, as what Aunt and Aaron has said, then we can't have a non-Aboriginal CEO, which is it needs to be at the moment, actually do it, because then it goes against what we're trying to say. So VACA was endorsing that at the last ACF, but I think we really need to take that into consideration. If this is the way that we're going, you can't not have an Aboriginal person at the helm of it.
Yes, it raises a lot of questions about education and training in this space, of course, but leave that for another day.
Can you just, with that one again, you said VACA endorsed it, but where is the push coming from to change that rule that currently says the CEO has to be...
I'm not sure where it's coming from. Obviously, it was raised at the ACF, so it's coming from somewhere, which is just, it goes against, you know, whether it works in whatever community it works in or not, it goes against what we're talking about is self-determination. So I'm not sure where the push and pull is coming from, but if it's at the ACF, it's come up from somewhere. And as I said, VACA, at that stage, it's documented and minuted that it was endorsed. So I find that really contradictory to what we're trying to achieve. I'm not saying we're all there yet with Section 18, but the whole point is every one of us here on this panel, our true belief is safety for our children as Aboriginal people and ensuring that there's cultural overlay there. So whether it's Section 18 or not, that's our true belief. Now, if you're going to do a Section 18, without being offensive, you don't want a non-Aboriginal person leading it, because that's the whole point, is true self-determination for Aboriginal people.
It does raise some interesting questions. It was actually coming from communities that already have a non-Indigenous CEO in place, but they have an appetite for Section 18. But it does raise an interesting question in regards to Nernda had Section 18 or pre-authorisation Section 18, and we went in under administration with a non-Indigenous administrator. So, you know, what it raises the question, what happens to those Section 18 programs in the event or unlikelihood that they do get a non-Indigenous worker, you know, as the CEO in place. So does that mean that they lose those programs and lose all that good work and that traction that they have? Or do we come up with another mechanism where that program's still able to be managed by those ACOs? And I think it was endorsed in principle, and there had to be additional work that had to be done with it, because there hasn't been full discussions at this stage. But there is a lot of issues there that has to be considered.
Oh, that's the one question I had. Thank you.
If you don't mind, Councillor, I'm just going to go slightly off track, if that's okay. Shelley, you mentioned before that you guys have a sobering up centre? Or
No, we don't. That was Rumbalara.
so is that new, or is that? So when was?
Yes.
You could explain that.
So many years ago we used to call it was called Gower House, and the department defunded those. There were a number of them across the state as a result of the changes and the Royal Commission and the detoxification rulings. They're trialling some sobering up centres throughout Victoria. There's 2 Aboriginal ones. One here in Melbourne, and it's been run by Darty, and we're going to trial the other one down home. So the building's just about completed. Staff have been recruited, and hopefully it'll be operational in a couple of weeks.
So I'm probably going to, sorry to go off track a bit. I'm going to ask you a question that I asked yesterday. So we had Minister Gabrielle Williams, and she gave evidence to us that the government remained committed to the abolition of public drunkenness offence, but there was delay for COVID, but also while the government put appropriate health services in place. So given that was back in May, and given the commitment was made after the death in custody of Arnie Tanya Day in 2020, what would you say about the government sitting on that reform?
Well, I have to agree. There were everything that you've just mentioned, which Gabrielle spoke about, is correct. But yeah, so the old models never had a clinical response. These have a clinical response. And trying to recruit clinical nurses to this has been a nightmare, taken much longer because that workforce is and still continues to be furloughed. There's certainly been some delays.
Auntie Muriel also talked about the night patrols, and instead of a respite or drying out facility, the use of night patrols, are they something that you would see as useful?
Well, you could use physically the resources of the night patrol, but technically, no, you wouldn't. Night patrol tends to, for us down home, it has a youth focus, and sobering up centres are for adults.
Yep.
So, and they are a combination of male and female. So, our night patrol focus, has the youth.
Thank you, Vance.
Any other questions, Commissioners?
Kevin, you?
No, I've asked the one question I had. Thank you.
Yeah. So I just might ask before we let the panel go whether there's anything burning that you feel you haven't shared yet that you wanted to say before we conclude the panel. I will tender your outlines as evidence, and there is an opportunity, if you wish, to supplement those outlines if there's things you think of beyond today. So to do a quick whip around, see if there's anything that hasn't been said that you'd like to address.
I guess I really want to talk about the funding for foster care and kinship. This is a little bit of a tangent that I'm on at every panel that I can get or any forum that I can get at. We're talking about most vulnerable people we suffer our own traumas a lot of the time. And as we've spoken about many times, is that we are a village and it takes a village to raise a community. And this is where we're at. So, I think in the proactive way is that if we can get children into kinship and cared, before they actually go through the full child protection process and it gets that bad, we want to be able to do that. However, if you're a kinship carer, the process is really short. You have to effectively be above 18, working with children check and police check, and it's done within 5 minutes. And then you go and you can be funded to support that child at a really low rate. You automatically go in at a particular level. Now, if you think about our most vulnerable families, they already are at a low, we've got risk of homelessness, we've got financial burdens because of the extra children that we're having if we're doing that. If you go through the accreditation process to be a foster carer, you go in at a different level, the level that actually has been sought after for you. And so, I've put in my evidence, the different scales. Now, the issue that we have here is that we have very few accredited Aboriginal foster carers. Why? Because the accreditation process is not accessible for our community. We've talked about education. So it is a process of 6 months. Less than 1% of Aboriginal people go and actually succeed at it because it is not been structured, exactly what we've said earlier about schools, it's not been structured for Aboriginal people. They can't complete it because of our low literacy, but also the way we learn. We don't always learn sitting in front of a person listening. So it's not tactile. And so at what point do we change that and look at it and go, it's not working. We're only getting 1% of foster carers of Aboriginal people, and that data has been for years now. Yet we've got kinship carers and they're prepared to do it, but they often decline because of the financial burden of taking on a child. So at what point do we actually look at the accreditation process to get them into as foster carers to make sure that they've got the training set out for them so they can be funded well enough to do it? Because we all put our hands up to look after our own children. However, the burden at the moment is enormous and nothing is changing. This has been going on for years.
Thank you.
Thank you.
Another thing to add to the education list.
So effectively, Aboriginal families are getting paid much less.
Unless they become accredited. And of course, becoming accredited is a 6-month barrier. Yep.
It's a little bit more than that because part of the foster care assessment is that they have to look at their own trauma so they can ascertain what their triggers are. Because children are very good at finding your weak points and pushing that button. So if they... Look, not all of us know about our trauma. You know, I came into this fairly strong person. My children had never seen me cry. But when I talk about our children, you usually see me cry. And because, you know, I'm passionate about it, but also because I've got traumas that I've never recognised, you know, and these kids trigger my trauma. So, you know, and I'm fairly strong. If you've got someone that isn't as strong and you're asking them to review their history, go back right to childhood, review their history and tell us what triggers your trauma, that's a challenge for any healthy person to do. Not to mention someone who's never lives with that and it's the norm for them.
Just really quickly, and it's probably yes or no because I'm aware of time. Do the agencies assess the carers, foster carers?
If you're a foster care agency.
You'll do it. Otherwise, does the department do it?
If it's kinship, the department do it.
Okay, thank you.
And is that a function that will shift to Section 18 organisations or not? It'll still be
Well,
outside.
it's up to the agency. We run a foster care. We're in the early stages of foster care, and that's a really difficult arena to get into. We've been doing it for 3 years, and we've still only got 4 foster carers. You know, we've done a massive, big advertisement for it. We've got something like 12 people interested, but when they go through the information session and realise what commitments they have to make to do the training and then to do the evaluation process, it's too burdensome for them. The other thing that we haven't touched here is homelessness. You know, our kids that age out, we've got to have sufficient accommodation for them to go into, and there needs to be programs that teach those children or young people at that stage how to pay their bills, how to look after those houses and how to, you know, maintain it and how to keep their door closed.
Are most of the children exiting care, are they having those services dropped off at 18 or are they eligible for the flow-ons now?
They get leaving care, and I forget what the other program...
I think I mentioned it the other day, Better Homes or...
Home Futures.
Yeah. So they get those. But, you know, if you've got extremely traumatised children, like we've got one that's ageing out now, she's had lots of trauma. She came in the other day broken down crying. She said, I don't want to leave yous. And we said, well, we were always going to be here, but you're 18 now, so you won't be officially part of our programs. You've been referred into Better Futures, and there's another, I think it's something else, Felicia. And they'll work with you, but, you know, any time you need to come in or you need additional supports, come in and talk to us, because we're perceived to be their family. And family don't shut their door. But there is a lack of homelessness and there's education. So, you know, you've got to make sure that these kids don't exit and then go and sit in the gutter and wonder where they go to, that their life has all got to be set up. They've got to be on an apprenticeship, some sort of employment. It's not good enough to put them into Centrelink payments, youth payments, and they've got to have some sort of accommodation. And most importantly, which a lot of people don't understand, how do you close that front door and be responsible for it? And we have those conversations with a lot of our vulnerable people who open their doors up and then they're in trouble. You know, you've got to regulate who comes in and out of that door. And yes, some people, yes, they might be homeless, but if they're not going to be good for you, then you shouldn't let them in. And the same has to happen with our young people.
Chair, I tender the outlines of evidence of Shelley Strickland, Felicia Dean, Aaron Wallace, Tracy Dillon and Auntie Hazel Hudson. They'll be numbered 3.1 to 3.4 respectively.
Thank you.
That's the evidence of the panel this morning. We've asked Auntie Rio to be available at 2:00 if that suits.
Yes, thank you. And thank you, Aaron, for being on. Look forward to meeting you sometime in person in Bendigo, perhaps. Thank you. And thank you all. Thank you all very much. Thank you, Councillor.
Thank you, Aaron.
Adjourned until 2:00.
If the Commission pleases, I now call today's next witness, Auntie Rio Ellis.
Thank you.
Thank you.
Welcome, Auntie Rio. Auntie Rio, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
You've prepared, I should say, a witness statement today, which is dated the 7th of December. Are the contents of that statement true and correct?
Yes, they are.
Auntie, will you introduce yourself to the commissioners and give them some background about who your mob are?
Of course. To those who don't know me, I'm Rio Ellis, community member of Naarm, Victoria. Been living off country for over 54 years, showing my age now. But proudly, I'm here to support people who sort of don't have a voice against the injustices that are being done to them today via the Child Protection Services, via working or being a volunteer for GMR Victoria, which is Grandmothers Against Removal. And that just as a volunteer capacity, we just got incorporated. We operate out of just from phones and all that, but hopefully, you know, we're getting known in the community.
Thanks, Auntie. I might go a little further back and just start with your own personal experience. In your witness statement, in your outline, you've mentioned that your parents were stolen generation. And could you tell the commissioners a bit about that and about the impact that had on them and on your family?
Yeah, absolutely. I guess what happened to them it's made me what I do today, I guess. Being stolen generation, then keeping us in the bush, and them being seasonal workers, of course, but more so keeping their children in the bush, because in those days, if you were paper bag brown of skin colour, you'd be taken so that you can be assimilated, then maybe through marriage and all that, easily turn white. So that's what Mum and Dad kept us in the bush for, and we've been told that, you know, it was a hard life and all that, but I I see it as, well, why, you know, our backyard was the mountains and the waterfalls, and our pets were the kangaroos, you know, the goannas and all that. So growing up, it wasn't a hard life for us, but we've learnt by it. Yeah.
And you mentioned in your outline that while you were still relatively young, your mother passed away, and that brought child protection into your life to an extent. Could you tell the commissioners about that period?
Yeah, well, I was only 17, turning 18, 77, pregnant, ready to have a baby, and Mum passed. And when Mum passed, we took on our four siblings. When I say we, I talk about my darling sister, Stormy, and we had she was called a welfare worker then, and to stop I don't know what it's called, to stop child protection from taking the brothers from us. So she helped us, and that's where we very humble and saying, you know, respect the people that help you. But yeah, that was the start of us looking after or fostering children, four brothers, you know, siblings.
And can you talk about your own personal experience of fostering children and how the Aboriginal culture does deal with that when other people can't look after their kids, when you've stepped in?
Yeah, it sort of goes back to how we want to bring back that saying, or bring back the village that raised a child. If anybody's having problems, well, somebody will put their hand up and say, well, I'll help out. So that's what I've done, and I've sort of fostered 7 children plus more. There's about 3 or 4 of those that actually was put in my care through child protection, but the others, like 5 or 6 of the others, were just came and stayed. Oh, Auntie, can I stay with you? And your mum allowed it and things like that. So that's how we was, where I wasn't questioned by a department or anything like that, because there was an auntie looking after children, you know.
And what's in those circumstances where your care for those children was not overseen by the department, did those kids stay with you forever, or did they come and go back to their parents when they were ready? Or
yeah, went back to their parents. One didn't, but now she's a registered nurse, and you know, good guidance from me, I suppose. But
did she stay with you?
Yeah,
she stayed with you the whole time.
Absolutely.
Yep.
Yeah. My Mandy, I've got to mention her. But yeah, and that's what we do, you know. And I guess probably down along my statements you'll notice that we do it because that's what we do, you know. But I think nowadays with the introduction of so-called child protection, that's changed. It's sort of taken away, and again, I'm feeling in my mature age years that this is another way of oppressing us into submitting to being a so-called norm, you know, in a white society, which we're not. You know, and that's what I take on.
And your outline talks on that issue about applying white middle class standards to Aboriginal families.
Yep.
And so how have you seen that? What are the kind of comments that you hear from child protection worker which has made you think, well, that's just not how we do things, or that's applying a different standard?
Well, it just stands that we are different, and you can feel them thinking that, oh, because you're different, you're wrong. You know, I feel that, okay, well, they ask a question like, what can we do to fit your mould? And the only thing that I can think of is not be black, because we didn't grow up in a middle-class home where, you know, we had supports around and all that. We actually strived to be where we were. But at not one time was a child at risk, you know, or maybe subjected to whereas the department will nowadays remove a child on that big say-so and under the guise of protection, with no substantial evidence, to say the child was at risk.
One of the comments you make is that you're aware that a child protection worker, one of their criticisms was that a child had dirty feet.
Yeah.
And is it your experience that those signs of a child who's maybe spending time outdoors without shoes, those things that you might say are things that your mob do without thinking about them, giving them a second thought, are viewed as children not being cared for or being neglected?
Well, the inference in that case was that you're not looking after this child properly. He's got dirty feet. Common sense in the department is not so common. So you'd think that, we had to say, well, there's mud outside. That's not neglecting the child. He's come inside from a muddy backyard. But and I've got to say that if they're doing this by the book, having a dirty foot or a child having a dirty feet is not in that book that they're following. It's just sometimes they're made-up versions, and that's got to stop because it's denigrating a parent. It's questioning her parenting skills, There's instances where they've done a check on a house, assessed a house with me on the phone to them. They found that everything was okay, but there was a big pile of clothes on the lounge room floor, and I said, "Why is the concern there?" And they said, "Well, the child might fall over those clothes." I said, "Well, no, the mother's going to fold those clothes soon." So that's how we've got to speak to them. And so who's training them to do this? To say those kind of things, it makes the department look silly, so.
Andy, I want to step back and just get you to explain a little bit about how GMAR got set up in Victoria and a bit more about the nuts and bolts of who GMAR is and what you do.
Okay. GMAR started in Victoria through...
And I'm sorry, Andy, I've just jumped into calling it GMAR.
GMAR Victoria.
And that's Grandmothers Against Removals?
That's right, yeah. It's Grandmothers Against Removal, Victoria. Just use the acronym GMAR Victoria, and we're getting known all around the state and Australia by that name. But we got established in 2018 when I think Lydia brought a founder of GMAR in New South Wales down to start a chapter in Victoria of Grandmothers Against Removal, because they started one in 2014 up in New South Wales. I don't know whether I'm right or wrong, can correct me if I'm wrong, but I see us down here at Grandmothers Against Victoria going in, providing support to families on the grassroots level and being with them on, supporting them in courtrooms, holding their hands, maybe writing letters for them, because we're going in as just grandparents. We're not lawyers or academics or, we're just grassroots mob. And, well, I shouldn't say just, because, a lot of people are thanking us for just being there with them. And that's what we do. Sometimes we question why the Aboriginal child placement principle is not being implemented. We question what is the, the cultural plan being written up for the child that's in out-of-home care. We question why somebody's having supervised visits as opposed to they shouldn't be. They should be just, having contact without supervision. We recommend, or sometimes we endorse, that we will actually do the supervision in the home, so that not at clinical offices or in parks or in libraries or at shopping centres, just to make it more culturally appropriate and homely for that child and parents, and probably families, because grandparents have access with their babies too. But yeah, Oh, there are a lot of things we do, and I guess we do it because it's just a normal thing that we do on a daily basis. And who'd question like, supporting a parent with some petrol to go and have access, or supporting a parent with go and doing their drug screens as part of the condition. So we support them in that way. We support them all the way because, one, that child knows that parent and knows only one parent. So if we can put things in place and support the parent, we'll do it. Yeah, and it's just by referral process too.
And you talk in your outline about how important the Koori grapevine is to you keeping your eye on what's happening with families or getting a hold of families. And there are some of the things you do, it strikes me that only mob could do. Are these things that a child protection practitioner could be trained to do, even if they wanted to?
Yeah, there are some child protection practitioners out there who are receptive to learning what we do, and making it more, I guess, not as clinical as it is, because at the end of the day, we're working with children and we need to look at their emotional, traumas, that may come along with being removed from mum and dad or even grandparents. But we do a lot work with some practitioners, some really hard-headed. They don't want to think that we're better than them or whatever. And I say, well, we are the professionals because we are the Aboriginal people who want to do this. It's important that we keep families together, even if it means picking up a mum or a dad who has maybe relapsed, instead of kicking them while they're down,
If a family member does relapse, how does GMA deal with that?
Well, we treat them like like their family, and if they think that we're going to growl at them or tell them off, we say, you can tell us the truth. We're here to help you up. We're not here to knock you down again, darling, and if it's called self-medicating, it means you're sick somewhere, and let's look at that. And I think because we as grandparents or aunties, and we do have some uncles help, it looks like they're being brought into a family and we're not judging. So, yeah, that's part of our, I guess, well-being for our, I don't want to say clients, I just say family members. Yeah.
And it's not a 9 to 5 service, is it? You've received phone calls at 11 o'clock at night. What kind of demands does that place on you?
It's a lot, because I have my daughters and my grandchildren with me, but we take the calls. Like I take the calls, and there's one instance where I took a call at 11 o'clock at night, and she was frantic. She was saying, Auntie Rio, they're here to take my babies at 11 o'clock at night with the police. I said, all right, darling, it's okay. Don't let them in until I talk with them. And they actually spoke with me through the phone, wired or shut, everything. But I said, well, what's your concerns? And they said, oh, well, we heard it was reported that there were children crying. I said, well, ask the mum, talk to the mum. And she said, well, can we come in, and Auntie Ria do it? I said, well, go in and have a look if you're worried about the house. And she said, we just want to assess the house then. I said, well, go ahead, because I just had to talk with mum, and she didn't mind, long as that the babies weren't taken. But at the end of the assessment, I said, do you have any concerns about the house? And she goes, oh, no, not really. There's the clothes on the floor, and that's how that come about. So you see how we get the calls. It turned out okay. They went away, and the police officer rang me the next day, and they shouldn't have even been involved in that case. But that's how we get the calls. And sometimes on a Saturday, I took a call at 7 o'clock in the morning, whereas they wanted to, and this is the word he said, want to line up and fight the children. 7 children from 2 months up to 12. So, and that's how ridiculous it sounds, and it was until I spoke to the police officer. Just asking, is the department there? Is Lakijika there? Lakijika is a program from VACA that sits beside the department. And I said, no. I said, well, you don't have a right there, really. And he goes, we're just assessing the house. I said, and citing the children. I said, well, no, we done that. We done that yesterday. And he apologised and left. But it's just that thing that it's there, that they can do that,
In your outline, you talk about systemic racism and the fact that you don't call it child protection, you call it child removal. Why do you use that phrase?
Well, they are removing our children. And you notice I said the guise of protection. A lot of our children are not being protected. They're not protected from the traumas, like loss and grief. They're not being protected from being sexually abused. We're working with about 5 and over cases right now. They're working with, we're working with that. They're not protecting them from harm. Some, they might say that removal is the answer, but it's not. We've found that it's not. We get, I'm sort of staying away from one harm that they do is the emotional harm to young mums. And there was 2 suicides. We know that it was because of their intervention. And there was no need for their intervention when we have heaps of support around the community. You probably heard the saying, Koori kids and Koori hands. They're not allowing it to happen. You just seen Auntie before with using the word authority for Section 18. Who the hell are they to say you haven't got authority yet? Authority to bring up our children, authority to be the village that raised a child. And, it's those kind of things that if we're not talking about it, is there an inference that it's not happening? We've got to talk about it. We shouldn't be sitting back and waiting for, say, Invasion Day to march for our kids. We shouldn't be waiting for a certain day or whatever. It's every day that this is happening. It's every day that I'm not accepting colonised mob to tell us that we're bringing up our children wrong. Colonised people to tell us that you don't know about child protection, you don't know about protecting the child. We do. We've done it well before colonisation, and we'll keep on doing it. The thing is, let's protect our children collaboratively, because we're not dismissive of concerns. We go and have a look at it in a more culturally sensitive way. We have parents that will not, that know that they're not able to have their children back, but the children with grandparents, the children with aunties or uncles, so they're in that space, they're in that community space, they're with family. So, and this is why I wear this shirt, that our children belong with family. It doesn't mean our children belong with mum and dad, with family. Let's start doing that.
And what's your experience of how well child protection are investigating the possibility of extended family placements while mum and dad can't look after the kids? How well they are investigating that extended family?
Well, you can probably see I don't have any respect for the way they're saying investigating, because when they investigate, they don't investigate and they don't point out the good that mum and dad are doing, or they point out all the bad things. And I have to ask them, is there anything good that these parents do? And then they'll bring it up, But in the court reports, it's always not good until we start writing a report ourselves and we go in and we see it. I just think the authors of such reports need to be educated more. That's just me. But it's if I'm thinking that, we know that it's affecting our children in the community.
One of the things your outline touches upon is your evidence that these problems could be addressed with support so that families can stay together. What supports would you like to see child protection able to or required to provide before they consider removal?
Well, if there's concern that, a lot of removals are because mum has a history, and where terms, look, when they say that about our mob, our mum has a history of being with the Department of Child Protection, and they're using that to keep a child out of mum's care, and I just say, well, Australia's got a white history, you've got to remember that, think about that first. But they're dismissive of our concerns. They're not taking our concerns into considerations, and I feel that, is it because, one organisation, one office of child protection said, we don't have to tell you anything because your group's not incorporated. And, that gets you back up and you say, well, we're the professional Aboriginals because we're Aboriginals, you've got to take that into account. But they don't. But, yeah, that's us, I guess. I mean, I'm not a learned person, darling. I'm not. We just do what we do.
But I'm sure there are cases where, knowing your mob as you do, you're looking in and thinking, if child protection could get this mum this support, she might be okay. Yeah. What are those sorts of things where you think that, what kind of supports do you think they should be?
I question the reunification order because the judge placed them on a reunification order, but what is the department doing to reunify this family? Are they set up to keep families apart? If they are, they shouldn't have that reunification order there or the preservation order, that kind of stuff. Simply because they don't provide any support to mum and dad. They'll tell them, you got to do your screens, you got to do this, you got to do that. You've got to do your, some mental health training or whatever. And I asked the question as, why are you asking that? Do you have a medical background to ask that, But apparently it gets all reported back to the magistrate, and if it's not done, it's not done. The reunification order is up to the parent. Apparently. And yet, as soon as a child is removed and they find a carer, they actually give a carer, will get a carer a house or get a carer a car. And, which means to me it's widening that gap of reunification. It doesn't stand. I'm always questioning it. And I do say, and I get smart sometimes and say, look, you've got a big barrel of money, you can do this to keep families together if that's the case. Because, sometimes mum and dad may need that little support to come good. I know I needed it when I was a young mum. Yeah.
And do you see child protection using that big barrel of money? Do you see them using that to address the concerns they've raised when they remove children?
No. I've got to fight with them over for Met cards, Met tickets. Yeah.
You've talked a little bit in your outline about the Aboriginal child placement principles. Is your experience that those principles are followed in practice?
Well, no. I'm asking that question too much. Same as our other volunteers around Victoria, they're asking that question, and they're not getting answers. Why is this child with a non-Aboriginal family? Have you checked out the grandmother and all this? Some of them will say, yeah, but the grandmother hasn't got a working with children check. And she hasn't got a working with children check because there was a crime when she was 15. She's like 55 now. That's just one case. And it's still a barrier, for kids to remain with family.
with relatives that are deemed unsuitable, what do you think about the requirements that are put in place for a relative to be able to care for an Aboriginal child?
Well, it's like the person who's putting their hand up is going to be scrutinised, and then they look at their past record with the police checks. If something comes up in it, they will say, well, we don't see that as suitable. We have concerns about you being a carer, you know.
And is that those past criminal histories related to issues to do with violence or issues to do that put the child at risk, or are they unrelated crimes?
Well, when the crimes occurred, there was no children around. So, and there was no children in that grandparent's care. So why is it relative now when the grandmother wants to care for their grandchild?
Have there been instances where you're aware of there being extended family that Child Protection haven't contacted who would be suitable?
Yes, and they accepted our. We've actually went around and we've said, "Well, look, you've never looked for family." So we've done that. We've looked for family, and in a couple of cases, we've got family to look after their sometimes it's brother and sister that's grown up, to take care of their sisters and brothers. Sometimes it's grandparents, and sometimes they happen to have a working with children check. But of late, when I think working with children came in, a lot of people don't have it, so they said, well, you can't have your grandchild.
And are Child Protection supporting extended family members to jump through those hurdles to get those checks or figure out how to get them?
No, we have to teach them. And funnily enough, we're not learned, but we're learning. Funnily enough, we had a case where an auntie had her 6 months, well, the baby was placed in her care when he was 2 weeks old. And then later on, he was 6 months old, and they said, Auntie Rhea, they're trying to take him. And I said, what for? She goes, because I haven't got my working with children check yet. I said, but they placed him in your care without a working with children check. And she goes, yeah, but they've come back now. And so it just so happens we was there at the right time, and we said, what are you doing here? Oh, what? So they knew while we were there. Oh, we're here to, take the baby. I said, well, what's your concerns? I said, baby's been looked at. Yeah, she's really good, the auntie, I said, so what do you want to take? Oh, she's working with children, hasn't come back yet. I said, yeah, well, that's not her fault. That doesn't make her a bad carer. I said, you need to get on to working with children, because they were the ones who was really slow in giving her the working with children check. So that worked out. Baby's still with her, and now mum's having sleepovers with him. So,
and so that placement would have been interrupted because of processing times for checks.
That's right, yeah.
You talked a bit about this focus on individual children and not the family as a whole. And how do you think this focus just on the child and not on the broader family, how do you see that having negative impacts?
I just see it as a part of, I see separation as I don't know whether I'm being radical or not, but that's another, I think that's the start of genocide, or it's a continuation trying to cause genocide, because we're splitting up a family when there's not necessarily so. Because, okay, if a parent cannot have their child, and we might agree to it, again, we'll say, where's the mum? Where's the grandparents? Where's the aunties and uncles? Where's the and we'll get. And then lately people are starting to put their hand up because they've got our support, because people are saying, well, I don't want to put my hand up, because they start questioning me and doing this, and I don't want to compromise my other children that are with me, because that's how it seems now.
Is this where mob are afraid to put their hand up to have Child Protection come and assess them?
Yeah. And the sad thing is, where's the... Like we've gone to houses and done assessments with child protection. We expect Lakijika to do something like that if that's the case in Metro, or I think we got VACA up at other areas. But that's how we want to look at VACA and say, well, wait a minute, where's Lakijika? And if they're under-resourced, what's the government doing? Is the government allowing this to happen, under that Section 18? I don't know what comes under that section, but really it's not allowing mob to look after mob.
Looking at the legislation, you've mentioned Section 18, which we'll touch on self-determination in a second. One of the issues you've raised is the breadth of the discretions under the legislation. It uses terms like unacceptable risk, and you've said that it uses open-ended words that leave a lot of discretion, that's really vague. When it's left vague like this, what is the result for Aboriginal people, do you think?
We've become there's a feeling of despair. They've written that about us. Is it true? Until we come in and we say, well, wait a minute. Like 80% of our children that are removed because of that big word, may be subjected to this, may be subjected to that. Again, there's no evidence. So I say to them, was that child ever harmed in the parent's care? If they come back and say no, why is it necessary to remove the child? It just doesn't make sense.
So in your experience, are these removals, is there a lack of concrete evidence of harm and neglect before a removal?
Yeah, it just looks like it's inference that there will be something going on there, or that they will be subjected to this. Now, why would you ask that? Let's put something in place if you have concerns. Removal should be the last resort. Let's look what we can do prior to removing the child. If we're not here to keep children in dangerous places, and I think that's what we fight to let the department know. You should look at us as working collaboratively with you, because we want mob together. We want a good outcome for the child, and and the family. Let's bring back that village that raised the child. There's been a lot of good, and to just take the child because of this is happening with mum or this is happening with dad. Don't send them away. Give them to a grandmother and grandfather or something like that, in which we, the community, the whole community, will know what's happening with our mob. We get instructions and we get endorsements or recommendations from community. We don't.
When these concepts are left really vague in the legislation, it must leave a lot of discretion to the individual worker. It must make a big difference which individual worker you get.
Yeah. Is that the worker with child protection?
The child protection worker.
Yeah. And like I said, you can see them coming. You can. Oh, what a term! You can see a good worker as opposed to one that have an air of entitlement about themselves. They'll speak down to you. They'll not look at. They won't even look at us as if we. Like I'm a community engagement as at VARS. They still won't. They'll still talk down until they're pulled up. Very nicely, but they're still pulled up and said, "Listen, you don't need to speak like that." But they do. I just think that, again, they need education in sometimes it's human relations, really, when you think about how they speak to people and all that, they need a little course in human relations, and not to mention Aboriginal culture. And, they want to talk about being diverse. Well, you be diverse, even learn learn about the people that you're working with.
You've also raised an issue about turnover with child protection practitioners and an experience with one very young child who'd had a really large number of workers in their short life. What issues does that lack of continuity of worker create for a child?
I just think of all the strangers that have been placed in this child's life, and it's done legitimately, but they're still strangers, They're not mum and dad, they're not auntie and uncle. But to have that many workers in that child's life, and that worker, the first worker, not moved from the office, they're still in that same office, why is the reasoning? Why are they removed from that child's life? There's no continuity. And today I've counted, there were not 5 workers, I've counted 7. And so I was on the phone to them yesterday, but they're not budging in. They're applying for a order by secretary under the grounds that they're not telling me because they don't have to. The information belongs to the child.
And this issue about having a GMA having any status or any ability to require the department to tell you things, you've raised that, and you've raised a desire to be able to intervene so that you could speak in child protection proceedings.
Yeah. In a deadly world, we would like to be made automatic party to proceedings. But at this point in time, they're putting up this barrier where you've got to be close to the child, or you've got to be either the mother, father, or the carer. And we say, well, we're there for the parents, like the lawyers are there for parents, and we're the support. I don't see why it should stop. There's one instance where we are party to proceedings, and that's in the Broadmeadows court, and that's only relies on whether the department will allow it. So we can't go ahead. The magistrate may say yes, but you've got to ask the department for permission. So I think that's a set up to fail type of thing.
You also, when talking about sort of proposals for the future, another reform you would like to see is when there is going to be a child removal of an Aboriginal child, you're notified of that.
Absolutely.
And
Absolutely.
What would that allow you to do if you were notified before a child removal decision was made that was likely to happen?
Well, we'd go in and if that's the case, we'd go in and see, well, what is the concerns from the department? Why is a report going in? And if there is such things as child abuse, well, we'll put a stop to that. And, you say, well, look, you may have to leave the home or whatever and address this and talk with the department, and say, well, look at other avenues so that the child is not removed. What can we put in place? But if it's cases like clothes on the floor, it's like, come on, let common sense prevail. Yeah.
When the departments raise concerns, can you provide some examples of where you have also shared those concerns? Can you provide any examples of where you have been in the home to sort people out and speak to people about, what's not working?
Well, sometimes when we see a parent who does, fail to cease drinking or taking drugs and stuff like that, we say, okay, if you want your children, what do you want to do something about it? We put the, we put the onus on them. And they go, well, Auntie, we don't know what to do. I want to give up, I said, all right, well, let's do this. Sometimes we contact Dadi Manwara And we do, like I said, we do things on a referral process, but we're still there to make sure that family member don't feel judged and things like that. Again, there's no, the child hasn't been harmed by it. It's just that it's interrupting the family dynamics, you know. And there's been good rapport with Dari Manwara, the men's behavioural program, and they have a women's behavioural program. So we know all the links to keep parents in the home and to keep children in the home. So I'm hoping that sometimes the department will come to us and say, well, look, what can we do, you know, in the means to keep children in the home.
I wanted to talk a little bit about self-determination. Some say that's already in the Act. Does Aboriginal family-led decision-making provide self-determination for Aboriginal people in this space?
No, because at the end of the day, from what I've seen with some AFLDMs, that's the Aboriginal family-led decision-making. We're put in a room thinking that, okay, we as professionals will leave the room and let you talk. So if we the family come up with an outcome, we take it back and we let the professionals know. The department will say, well, we don't think that's right. We have a concern with this. So I said, well, why is it called that? You know, I mean, it could be seen other ways, but when we do that, we get this false, well, we get a false belief that, or false hope that we're allowed to have a say. You know, sometimes that's not the case, and that's not self-determination. Same as when the department, I guess, dictates to ACCOs that hold the Section 18. They're actually telling that department, that ACCO, what to do. So where's the determination in that? You know, we know what we're doing. We're mob.
But doesn't Section 18 put Aboriginal-controlled ACCOs in charge?
Yeah, but they'll say that they walk beside them, but they dictate to them. VACA's got some awesome programs that will keep families together, but again, that's at the discretion of the department worker. So I can't refer to Noogle House. I can't refer to the Restoration House. I can't refer, and even I guess the Victorian Aboriginal Health Service can't. VACSAL can't. No one can. It has to be the department. So you know, I think that's 2 steps forward and 1 step backwards in self-determination for that ACCO.
The other aspect that some would say provides for a measure of self-determination is the requirement to have cultural plans under the Act. What do you say about those plans?
Is that legislated?
The cultural plans, and is it your view that it should be mandatory?
It should be mandatory because it's not happening. It's just not happening. Because we know who's the cultural plan officer at Nyunda. We know who the cultural plan officer, say, at Badak. And when we want to make a report on it, and because we believe that that person has to make a report and give it to the department, but also give that report to the parent, so the parent can say, oh, okay, that's right, that's from my family line, that's part of my family tree. It's not happening. We may have missed something as GMAR workers, but we don't see it happening. And we do get around to actually visiting mob without just over the phone type of thing. And we know, 6 degrees of separation, I suppose we can put that down to.
Another aspect of self-determination you raise is courtrooms.
Yep.
You've attended Maram Nagala Gambu.
Gambu, yeah.
At the Broadmeadows Children's Court. How is that different from the normal children's court? How does it work?
Well, it takes into account the cultural aspects of the families that are going there. when you walk in, you don't feel overwhelmed. You don't feel like, God, this is quite confronting. It doesn't look like a courtroom because you have the possum skin on the table. You have the magistrate sometimes sit down at the table with you, not sort of up there and looking down, and it relaxes. It doesn't frighten parents. I mean, sometimes the department and their lawyers frighten, the families, but it's not as clinical as a courtroom. So, it encourages families to talk up to have a say.
And what role has GMAR been able to play when proceedings are happening in that court?
Well, if they have any questions, they can ask us. We'll answer it in a layman's term. Don't know, probably because we don't know the big jargon. But just hold their hands, let them know, that this is just part of the process. And, at the end of the day, the big picture is baby's going to come home. Yeah.
You speak in your outline about the impacts on families, on children and families of having a child removed, and you spoke a bit earlier about some mob that have been lost as a result of that.
Yeah.
What other impacts have you seen on families who lose a child?
We don't like that term, lose a child, when we say when a child is removed. It can lead to alcoholism. It could lead to drug use. It's that way of self-medicating again, because that person's going through a lot, and that's the only way they know to what would you call it, to get by, I suppose. Self-medicate, and then we come in and it's not as simple as I'm sounding it is, but there is that hope, give them hope and stuff like that, okay, let's deal with your self-medicating, because we know that if self-medication, you're looking for medication, let's fix it somehow. And sit and have yarns and things like that. We're there to hold your hand. We're here. Your children love you. You're the best one in their eyes. So you've got that with our support. Yeah.
And is that something you've ever seen Child Protection do?
No.
So in your witness statement, you talk about wanting to know what the department means by reunification when they keep moving the goalposts and putting up barriers. When the department has a reunification goal in their documentation, in the report they put forward to the court, they'll say, our goal is reunification. To what extent do you see them actively working to bring that about, to get reunification?
They act actively by telling the parents, do this, do that, jump through this, jump through all these hoops, your child will come back to you. 12 months is up. Oh, well, no, we're going to go for a preservation order, or not preservation order. We're going to go for a order by secretary because we really have concerns. Those concerns have been addressed, so what made them more concerned? They didn't answer, they don't answer. But they're going to go for an order to order to secretary, I think it is. And Mum and Dad has been jumping through the hoops, so what else do they have to do? And he goes, well, continue doing their SUDs, which is, drug screens. And I said, have they had a dirty screen in the last 9 months? And they say no. So why are you being, so that kind of thing. And they do it because they can. And the magistrates listen to their reports, not ours, and not, WACA won't write a report because they'll tell us that their client is the child. So they're acting on behalf of the child, and the best interest of the child is to stay away, as the department is saying, be kept away from Mum and Dad. And that's what the department's saying. So this is why I know that Section 18 is not working. It's not working.
You have raised concerns about the supports that are being provided to children after they've been removed, counselling and things like that. What are your concerns and what have you seen is lacking when kids are removed?
Yeah, they're lacking supports in getting that child counselling, because when you lose somebody, you go through that trauma of loss and grief. Why are they not taking it on board that this child is grieving for mum and dad, and mum and dad go and have contact and they have to leave the child is threatened for mum and dad? That's another form of emotional trauma that they're not addressing. There's a lot of cases where children are actually being, left in motel rooms unsupervised and all that, and they call that safe. It's not, and this is children on the spectrum, no sensory things, whatever involved, just left in a room with a game and all that. And we speak that because mum's shown us evidence, and we're wondering why and why do they call it protection? So, yeah.
So these cases where you're in contact with mum,
Yep.
and she's had an access visit,
Yep.
and is upset about the circumstances in which she's found her child.
That's right, yeah.
I want to talk about a little bit about your funding. Currently,
What's funding?
yes, I was going to say, do you get any funding?
Well, no, not at this point in time. We did have a funding body that did help us, but that ran out. We reapplied, but until things happen, we just have to wait.
So how do you operate?
We operate as we do.
So
Like,
it's
as a community
all
member.
voluntary?
Yeah, we are a voluntary group. We refuse to get government funding because of the strings that may be attached. If they don't attach any strings, well, we may take their money. But donations, which is far and few between, but hopefully later on when we have a website, we build this, we get our data collection, all that, maybe some things can come into place, like our usual donated or philanthropic money. But, at the moment, we're rich in pride and culture. We're poor in the bank, but, we're still there to take a phone call. We're still there to go to court or, things like that. It's a $2.50 tram ticket or train ticket, and what's that to us? Sometimes who just want to support people.
And when you did have funding, what were those? I'm assuming the grandmas were still working voluntarily. What was that funding being used to do?
The funding was being used to ensure that mum and dad have petrol to go and have access, maybe to furnish a bedroom when a child got returned home, maybe to back to school packages, and just to support mum in that little way. We bought washing machines for mum who's never had her kids in her care for 4 years. And just muggy tickets to get them to court or get them to places where they have to do their drug testing, which is they won't allow them to attend the Victorian Aboriginal Health Service. And I asked that question because that's the other places that are not culturally appropriate, and some people do have stage fright, so to speak.
So they can't do their drug screens at the Victorian Aboriginal Health Service?
They can't.
And is there a reason? Do they not perform?
Well, they did say some sort of training is required to the thing. I said, but we've got medical nurses, we've got registered nurses, and they go, yeah, but they're not trained in that kind of thing. I said, Well, we were doing it 3 years ago. Victorian Aboriginal Health Service was, I actually done supervised screens, you know, but since 3 years ago, they've stopped that. I said, no, we'll have to do it. So I spoke with our boss at thing and let's do some training. But the ball's in their hand.
And in terms of funding, you talked about strings being attached. What's the concern for you about having funding with strings attached to it?
Well, you're not allowed to have, you know, somebody working with you who don't have a working with children's check. Sometimes that, if a person wants to get a job with us and things like that, they'd have to have their working with children's check. Or, you know, it's just, you can't, what's it called? You can't be radical or whatever, I don't know what the word is, but you can't be radical and go against the government and stuff like that. So
You'd like to have complete control over how you spend your budget.
Yeah, absolutely.
And it sounds as though there was a lot of flexibility in how you were using that.
Yep.
It was just whatever you thought would support parents having their kids in the home.
Absolutely, and we're actually governed by a 7-member committee, which is a president, you know, and directors and treasurer and secretary. So we're not willy-nilly in saying, okay, well, this is our rules, you know. We are governed by a committee and directors.
You also were talking about things to do with money. A little earlier you touched on the fact that after children are removed, the carers who they go with get a lot of financial support.
Yeah.
Is your experience that the family, before removal is considered, get that same kind of support?
Yeah, use those resources on the family who you're concerned about. You know, maybe.
Is that happening now?
No, because we see it very often now that children, and again, this will go back to the individual worker having a say. So one worker actually put 2 grandchildren in the care of their grandmother, which we said, all good, you know. The grandmother was homeless and living in a car. That was okay because she kept going to her daughter's place, so they gave her the 2 grandchildren. And yet, you know, they stop kids from going with their grandparents who's already got a house, got this and got that, and they'll give it to somebody else give the child to somebody else who hasn't got a car, hasn't got a house, and they will provide that car and they will provide a house, which means they talk to the managers of housing, and the managers will say, well, them 2 houses there are allocated for women or families who are caring for children in the department's, you know, realm, I suppose. Yeah. And that's how we know, because we're getting closer with the manager of housing, and she said, anytime you need, come to us and we can see if we can expedite a house for one of your clients, which, so, you know, they're going to help us and then they help the department. I don't know.
Auntie, I didn't have any more questions for you. The commissioners might have some questions, but before then, was there anything else that you wanted to say?
No, I just want to acknowledge that I sit here very, very privileged, a very privileged woman, because I know my culture, I have my children, I have my language, and I want the mob that I'm going to look after, that I'm here looking after, to have that, not lose that, and to know that there are people out there that care, you know, and there are people out there that want to push this envelope of so-called child protection to the back burner, because let us look after our children. You know, we know what to do, and yeah, that's me. Thank you.
Commissioners, any questions for Auntie Rio?
Thank you. Thank you, Auntie Rio. I've just got one question, and it's about Section 18. And I heard you say that Section 18 wasn't working, and I wonder, is it just the way the system is set up now that is not working, or are you opposed to Aboriginal people taking children away from Aboriginal families in principle?
Well, look, if it has to happen, it has to happen, because at the end of the day, I am going to remove a child from a dangerous situation.
Mm.
It's being unrealistic if we say, no, we don't want Aboriginal people to take our Aboriginal children away.
Yep.
We're going to ensure that if we do, we leave them with family.
Yeah.
We're going to identify a problem within our community. And I say that Section 18 is not working because they're sitting... We don't understand it. I don't understand it. I'm led to believe that Section 18 allows mob to look after mob.
Mm.
It's not happening. It's not happening when you, like I said, when you hear them say, well, you can't go to Noogle, you can't go to Restoration House until you get the authority off the department. And for them to say VACA hasn't got authority or Nyunda hasn't got authority, or even talking pre-authority and authority, who are they for us proud Aboriginal people to get authority from? They're not the professional in Aboriginal space. They're laying down a law like 230 years ago. They're doing that right now, and we're against that too. And if it means that we have to listen to them and do that to get money, are we using that money to look after our mob? Are we using that money to ensure that families are being well looked after? You know, just because a person becomes an alcoholic, we need to look at why. Because in our mob, there's oppression. They need to understand the oppressive side of it. They need to understand that some crimes have been done because of poverty, things like that. And they need to understand too that we are not, we haven't lived in the white space that they want us to. And that's what we have to do. But again, no, I really don't think Section 18 is working. When we heard it was coming about, we felt all warm and fuzzy. Oh, good, it'll be Aboriginal, look after Aboriginal. Then we thought, well, what do you think about Aboriginal taking Aboriginal? Well, if we are, it's because we have to.
Yeah.
Yeah. It's not like we're going in and we're doing this because we have concerns. We're going in, we're looking at the family, looking at why, but we're actually going to place that child with other Aboriginal families. And I don't know why the penny hasn't dropped on any of the magistrates there that keep making rulings, keep our children away. Not all Aboriginal parents are bad parents. Some are circumstantial, Thanks, Kev.
Thank you, Commissioners.
Thanks, Auntie. Look, listening to some of the evidence today from you and from others, it seems to me that there are an awful lot of petty bureaucratic barriers put in the way of Aboriginal people being able to look after their own. So there's the Working with Children report, there's the use of decades-old brushes with the law. There's the difficulty about getting accredited at a foster carer. There's the vagueness of what unsuitable is, and I just wondered your thoughts on sort of this legacy of barriers that still seem to be there, despite the nice words around things like Aboriginal family decision-making. They don't seem to... It seems to be
that's
contradictory to me.
Yeah, it's contradictory. It's farcical. It's not giving anybody time to speak. Again, the outcome of an AFLDM depends on a worker. If there's a good worker, and I say a good worker, common sense, look at what we've done insofar as investigating, insofar as assessing homes, assessing anything that they assess. We do it as an auntie or as a grandmother or as a sister girl going in, We do it non-judgmentally. That's okay, but for them to enforce their authority is going back to I guess when they wrote the White Australia policy, and it hasn't changed, you know, sadly.
Hi, Amy. I've got a few questions 'cause I just want to clarify some stuff. You mentioned the police being involved as well as DFFH. So in your experience in GMA, how often would the police come to a home with DFFH in your experience in GMA?
In the experience since 2018, we've had 6 cases. That's 6 cases too many. But, you know, there's some police officers that have said that, you know, we shouldn't be here. I said, well, move away, and they did. The thing is, when they were like 2018, and we didn't get off the ground until 2019, so, and then COVID happened and all that. So there was confusion with the police going in, and this is what I'm told by the sergeant. But it's just, you know, there's that police scare tactics, you know, the scare tactics. When you want to remove a child, why is police involved? Get the Aboriginal people there and talk with families and find out, because a lot of these children are taken unnecessarily. So look at the resources. Someone said to the police, why don't you go and catch some murderers coming here taking kids, you know? Why don't you do this? Why don't you do that? There's no reason why police should attend, really. If there's combative behaviour, then bring them. But they actually come with the workers on the assumption that there may be combative behaviour. You know, but by this time, that all the things that we've dealt with, there wasn't. So because we was there, and it was just a shame that the police did attend. Mm.
And you also mentioned hotels.
Yep.
How often, in your experience, are children ending up in hotels?
Well, unfortunately, we've got 3 cases now, and it's about when I say the motels, the children that are placed in those motel rooms are children that got ADHD or they're on the spectrum. So they haven't found a carer for that child, but they still seen the need to remove, or they're just seeing it as a need to remove that child from a routine that they've known. And I think if everybody here knows how a child on the spectrum, you know, needs routine, well, that's taken them out of their routine.
Can I ask what age are the children?
7.
In a hotel?
7, 9. Yeah, there's one that's 7, one that's 9. Yeah, in a motel. And when that was questioned, they go, we can't talk to you about that because that's the child's.
Anyway, who's looking after them in that hotel?
What do you call it, a respite worker? A staff member of the department. Yeah.
Thank you.
Yeah.
You said before that you wrote some reports as GMA. Who do those reports go to?
The magistrate.
So is it a certain court, or is it any court, or?
It's the children's, it's a court where the mum and dad have got to go. So that's the letters that we write, is called letter of support. So
and they're able to go,
we're
they
able
get to the magistrate?
Yeah. Oh, I don't know, I don't trust lawyers. So I send a report to the magistrate, their lawyer and the parent's lawyer, because it's, in the past, we've given lawyers these support letters so the magistrate could read, and they haven't been up to the magistrate. And we've had some lawyers that GMA's actually paid some lawyers, and they've not, you know, they're not represented, they misrepresented our clients, or their clients, which was our family members. So I said, well, I'm not trusting them, I'll give my letter straight to the magistrate so that we know it's getting read.
And sorry, because I just want to clarify some stuff. Like the AFLDMs you talked about, that's Aboriginal family-led decision-making.
Yeah.
Is it Aboriginal family-led?
Well, they pretend to go out, the professionals. What it is we're in a big room, we'll talk about this, talk about that, and then they go, oh, it's time for you to make your decisions and have a yarn about where to from here, and that's the family making that decision. So we will, and the family always invites me in as a part of their family, and the professionals leave, and then we discuss this, discuss that, and I look at I point them in a practical way now, and because I have sort of an idea of what they'll accept, and see, there it goes again, as what they'll accept and what they won't. So that's okay.
Only when you
The
say what
families are
they'll
happy.
accept, is that the department?
Yeah.
Oh.
Yeah, so we're there talking, and we're going to about information we take back to the department so that they can accept it. If they don't accept it, well, what's the use of having an AFLDM? You know, what's the use of that? And it's given the parents false hope that they have a say in the return of their child or the grandchild or whatever. But yeah, that's how it is.
And I just looked up the cultural support plans you were talking about. So there's two orders. If you're on a guardianship to secretary order, a long-term guardianship to secretary order, then you have a cultural support plan.
Yep.
Now, it does say in the planning of that, in their own manual, that family has to be a part of that.
Yep.
Have you
No, family do have to be a part of that, but they fail to in our work in the time that since 2018 or 2019, and the cases that we work in, they fail to provide to ask the family for information, or they fail to provide the report from the person that's doing the cultural plan. And the cultural plan goes to a cultural officer in Yoorrook or a cultural officer in Bendigo, whatever. That report is not being given to the parent. It's actually been given to the department. And when a parent asks for it, they go, well, that belongs to the child. Well, wait a minute, that child's only 3 years old.
they're not a part of planning it?
No.
And one last thing, why do you think the numbers are going up every year of children in out-of-home care?
I don't know. I asked that question. Why is it going up, given that we've got this Section 18? Since Section 18 started, it's risen. I presumed that it would come down. That's my assumption was that Aboriginal children in Aboriginal people's hands with that Section 18, it's not working. It's rising. Well, and again, I made a lot of the decisions of children to be put in out-of-home care sits with the magistrate too. So do we question the judicial system there? Do they believe, Do we question the magistrates? I don't know. How is that rising? It's not children are placed in out-of-home care because a decision was made by a judge or a magistrate. So let's look at how their way of thinking too, because they're going on some reports that the department gave, and some judges actually called some practitioners out for lying and reprimanded them, and that's what we have to put up with. But yeah, I mean, we've got to look at a whole lot of things.
Well, lots more, Auntie Rio, but I won't.
Yeah,
Thank you.
No, it needs to be heard. I don't know where it goes to from here. Given the fact that we've had to bring in the Mome report and how many recommendations got implemented out of that, but it's our stories getting told. A lot of the stories before me today is getting told, and people are hearing about it. So I just hope it moves forward, and there's support out there for keeping our children in the homes, not out of home care and away from family. We're a very proud mob. With all the, I guess, what would you call it? Not conflicts. When you say you're Aboriginal, you get all this trouble coming to you, and it was sometimes you don't get it if you're not a Aboriginal. But when the question gets asked that, do I think that there's racism in the system? I know so, because we're actually having this meeting today. If there wasn't, we wouldn't be sitting here today. I mean, do you see white fellas sitting around and asking questions? That's not there, and that's because we're waking up to the racist Australia. Thank you.
Thanks, Arnie.
Thank you.
Chair, I'll now tender into evidence Auntie Rio's outline of evidence dated the 7th of December 2022.
These documents will be allocated the next exhibit numbers. Thank you, Council.
We've now concluded today's evidence.
Thank you.
Thank you, everybody. Thank you. Thank you,
Thank
Aunt.
you.
Thank you very much, Aunt.